2008 madam. At the request of the council for reference list of the number. The request of the council for reference list of the number. Sir is saying something. I don't know why you people. At the request of the council for reference list of the yes. At the request of the council for reference list of the E.V. Krishnappa. For the request of the council for the respondent list of the witness. No, Mr. But is here number 64. Mr. Krishnappa. Yes, it was already heard, Mr. Yesterday, this matter is already heard. So it is already heard. Part of matter. Tomorrow. Correct. 4 weeks time granted to complete the office objections. Failing which the accused shall stand dismissed without reference to bench.
Number 2, TN Raghupati.
Please, Banta. You need something more? You're taken by car, dropped back. Put at India, la Kursadra ilva. What is this passage, madam? This is so front portion is 24.8 is it? ಮತ್ತೆ ನೀವು ಹೇಳಿ ತಪ್ಪಾಯ್ತಲ್ಲಪ್ಪ.
So now this element, the property is also included.
ನೀವೇ ಕೇಳಿಲ್ಲ ಕಮಿಷನರ್ಗೆ ಯಾಕೆ ಕೇಳಿಲ್ಲ? Why you did not mention to the commissioner?
But the commissioner has told that the court has reported the actual position of the property. Therefore, now we will submit it. We will submit it to the court. Therefore, we consider all the facts and also evidence on record that there is no dispute because we concentrated 36 feet the house land.
Sir, how can this map prepared by the commissioner and also the map prepared by the assistant director of land records, how can that be the same? ADLR bandaga, why you did not say that your property extends up to the passage or beyond the passage?
whether the property is reference same date. The concern with the area of Atata, they taken into consideration the measurement and the mentioned same. During the course of cross-examination in this proceeding, they clearly admitted there was no incision at all to measure the site as well as the vacant site. There was a specific memo of incision that the memo of incision has been submitted along with the report. We have submitted that.
I think photograph and the left side of the Yarmane, Karnataka and Telecast. To the left side, is it the appellant Manelva? I think 24 feet ಎಲ್ಲಿ ವರೆಗೂ ಬರ್ತದೆ ಇದು ಈ ಬಿಲ್ಡಿಂಗ್ ಎಂಡ್ ಇಂದ ಈ ಬಿಲ್ಡಿಂಗ್ ಎಂಡ್ ವರೆಗೂನಾ let the commissioner say ಇವಾಗ 307 ಗಡಿ ಇದೆಯಾ ಅಲ್ಲಿ ಈ ಕಡೆ ಇವ್ರದ್ದು ಸರ್ವೆ ನಂಬರ್ ಅದಕ್ಕೆ ಗಡಿ ಇದೆ ಅದಕ್ಕೆ ಗಡಿ ಇಲ್ಲ Yes.
So we retain the 40-feet plan mirror in the western side.
If you want the commissioner, we'll appoint a commissioner at your cost. If they want their property to be measured, we'll appoint a commissioner, but they'll have to pay the cost. Yes. Sir, will you pay the cost? If you are willing to pay the cost, we'll appoint one more commissioner to identify what is the boundaries of the property that is purchased by you. Are you willing to bear the cost? Yes or no? Sir, don't give your humble submission. Are you willing to bear the cost? Or could the counsel for the respondent the report of the commissioner is received. The commissioner has stated, has indicated in a report that the passage between the property of the respondents and Mallegowda measures 24 feet, 24.8 feet in the front and tapers to 24.3 at the rear. REAR. Tapers, TAPERS, tapers to 24.3 feet at the rear. Stop. And this corresponds to, and this closely corresponds to the report submitted by the Assistant Director of Land Records. Nonetheless, the counsel for the respondent submits that the commissioner has not measured and identified the property belonging to the respondents as per the sale deed. Full stop. The learned counsel submits that the commissioner may a fresh commissioner be appointed to identify the limits and the boundaries of the property purchased by the respondents as per the sale deed. Respondents is knowledge in either. You are a respondent. You are also one of the purchasers. So all the 4 purchasers. Of the four sites purchased by the respondents, and that he would bear the expense of the commission. Yes, whom do you want? You want an advocate commissioner, you want a survey commissioner, advocate commissioner. How will he do it without the maps, without the survey documents? Nale survey madilla, survey map illa. Stop. In that way of the matter, comma. Anybody, any advocate who is willing to go to Malwalli na idu elli? Malwalli. Yaro Malwalli or yaru idara? Anybody from Malwalli? The youngster there, are you willing to go? Man, the one in the last. You are the one. Are you willing to go and execute a commission? How many years you put in? You will be able to handle a commission. Right? In that way of the matter, Mr. Vivek N. Learned Counsel is present in the court, is appointed as a court commissioner who shall visit the properties in question and measure the 4 sites purchased by the respondents as per their sale deeds and fix the boundaries of the said sale deeds. Also measure the vacant passage lying on the east of these of these 4 sites and submit a report. Stop. The commissioner, the advocate commissioner may avail the services of the taluk surveyor by giving him prior intimation. So as to secure the survey maps to determine the boundaries of the properties purchased by the respondents. Stop. The commissioner fee is tentatively fixed at rupees 10,000 payable by the respondents to the commissioner on the date of executing the commission warrant. Stop. The commissioner is directed to inspect and report. Inspect the properties on. Will you want to do it? Do you have any plans of going out? No plans of going out. The commissioner shall inspect this properties on 10th May 2022 at 11 a.m. Full stop. The respondents shall furnish the title deeds to the commissioner on the said day. The commissioner shall intimate the taluk surveyor by or before 30th of April 2022 about the intended commission work. Stop. The office is directed to furnish copies of the survey report already prepared by the surveyor, Mr. Suresh DT, on 7/9/2019, on 7/9/2019, as well as the sketch of the prepared by the advocate commissioner and submitted to which was submitted to this court on 19/4/2022, and also issue a commission warrant Based on obviously, to write a letter, you should say that this is under the directions of the High Court. You should bring the plans, survey maps, everything, and cooperate with the executing the commission work. Failing which, the High Court will be informed that you are not cooperating. Based on 31st May. I have to let him verify this. Title confirm, very boundaries and title. Only boundaries. We are not confirming the title. Based on the sale deed, let him find out the boundaries. Let him find out the boundaries and also the passage. Not necessary. The memo of instructions put in the confusion. So please don't give any memo of instructions. Don't execute based on the memo of instructions. As what the High Court has directed, please do it. 10,000 has to be paid at the spot. Either it is made clear that the respondent shall make arrangements for the travel of the commissioner, comfortable travel of the commissioner to the spot as well as to drop him back at Bangalore. The respondent shall also ensure that the commissioner has submitted his report and has acknowledged the receipt of the commissioner. The report is accepted. Yes, next.
Kevin Narasimhan.
Also,
Number 4, Gangadhar. D. Rajana.
this was representation for 2 weeks, 4 weeks time is granted to comply the office objections, failing which the application shall stand rejected.
Number 5, R.P. Somsekraya.
2 weeks.
Wait,
So same part remain.
so you are a party to this compromise. You withdraw your compromise. You're not there. You're not a party to the compromise. Not a small, simple sentence in English. Were you a party to the compromise or not? Still. Where is Mr. Somsekhar? So no question of giving notice to the parties. Pass over. I will take it up.
Number 6, yes, Vasuraja.
Prostate will not forthcoming. Delayed case to be mentioned. Copy not served to the other side. Complaints of office objection raised on IS for bringing LRs. Full cost title not forthcoming. Delay mentioned. Copy not served. Yes. Barcode. IA 1 of 2022 is filed to bring the legal is filed to for condonation of delay in filing the application to come on record as the legal representatives of deceased appellant 1. appellant number 1. The office has raised objections on this application. The office objections are overruled. Accepting the caution for the delay, IA 3 of 2022 is allowed. Consequently, IA 2 of 22, which is filed for setting aside the abatement, is also allowed as the cause of action has survived the death of the appellant number 1. In view of the above, IA 3 of 2022 is allowed and the applicants are permitted to come on record as the legal representatives. Counsel for the appellant is directed to amend the cost rate. Next, office objections raised on IA 4 to 6 of 2022 are overruled for the present. Issue notice on IA 456 of 2022. ಯಾರಿಗೆ? The learned counsel T.P. Prasanna undertakes to appear for the legal representatives of R1. Do you have any objection? And has no objections to allow these applications. Issue notice on the consequently, IA 4 to 6 of 2022 are allowed. The legal representatives of respondent number 1 are ordered to be brought on record. Counsel for the appellant is directed to amend the cost rate. Furnish an amended cost rate. Could they file for the A6 ಯಾವ್ದು A6 IA ನಂಬರ್ ಯಾವ್ದು A6 ಗೆ ಕೊಡಿ. Four to six. Yeah. Notice on flag ಆಗ್ತಿದೆ. IA 1 of 18 is filed for continuation of delay in filing the application to come on record as the legal representative of appellant number 1. A1B ಅಂದ್ರೆ ಅದು IA 1 of 2018 is filed to bring the legal filed by the applicants to come on record as the legal representative of appellant number 1. It is stated in the affidavit accompanying the application that the appellant number 1 died before the first appellate court, during the proceedings before the first appellate court, and no steps were taken to bring the legal representatives before the first appellate court. Hence, the delay in filing the application to come on record. So the caution for the delay is accepted. Hence, IA 1 of 2018 is allowed. In view of the allowed. Since the cause of action has survived the death of the appellant number 1, IA 2 of 2018 is also allowed, and the abatement of the appeal is set aside. view of the aforesaid order, IA3 of 2018 is also allowed, and the applicants are permitted to come on record as the legal representative of appellant number 1. Next, IA 4 of 2020 is failed to bring the is filed by the applicants to come on record as the legal representatives of deceased appellant number 6. Stated in the affidavit that the applicants could not secure the death certificate in time so as to file the application to come on record, and therefore the application is filed belated. The caution for the delay is accepted. Hence, IA 4 of 2020 is allowed. Consequently, IA 5 of 2020 is filed for setting aside the abatement of the fee. So far as appellant number 6 is concerned, we set aside. In view of the above, IA 3 of 20 is filed to bring the 4 I2 5 to 6 cell, right? Consequently, IA 6 of 2020, which is filed by the applicants to come on record as the legal representatives of deceased appellant number 6 is allowed. Counsel for the appellant is directed to amend the cost statement and publish an amended cost statement. In the meanwhile, the requisite process fee and other requisites to issue notice to the respondents 8 to 10 shall be deposited. Yes, and full stop. If process is paid, office is directed to proceed to issue notice to the unserved respondents. Issue notice on issue notice on IA 1 to 3, 7 to 9 of 2020. Yes. First thing is cost rate amendment money. Specific performance of FTPL, right? So this is specific performance and the partition. Yes, Mr. You for the appellant. The learned counsel for this. I think the process thoroughly condone delay. Delay has to be condoned before granting any interim order. Mr. You please, what were you doing for all this? From 2016. Therefore, you should take steps. If you sleep, then this is what happens. Please pay the process status. Next. Password. Pradeep Kesi. Password. You paid, Mr. You recover from the party. The matter again will not be repeated. Sorry, password. 4 weeks time is granted to comply the office of elections as a last chance, failing which the appeal shall stand dismissed for non-compliance of office of elections without reference to bench.
Number 10, DP Mahesh.
In the acceptance of Chalan of Kotak Mahindra Bank for 2000 instead of filing an account bank, the cost. TD payable to whom? Payable to yourself. Huh? DD favoring whom, Mr. Angidya? ಇಲ್ಲಿ ತಗೊಂಡಿದ್ರಿ ಮಿಸ್ಟರ್ ಡಿ ಫೇವರಿಂಗ್ ಹೋಮ್ you furnished a challan, but Karnataka advocate. Where will this money go, Mister? Is there any head of account called Karnataka advocate? Athar account idya. But you look at it. Barcode. Please pay today. The challan of Kotak Mahindra Bank discloses that sum of rupees 2,000 is credited into the account of Karnataka advocate, while the petitioner was required to credit it to the Karnataka advocates clerks benevolent trust. Stop. In that way of the matter, the challan furnished to this court is rejected. Counsel for the appellant is directed to deposit a sum of rupees 2,000 to the Karnataka advocates clerks benevolent trust fund and submit a challan during the course of the day, failing which the appeal shall stand dismissed. Yes, please. But why will the defendant furnish the valuation? The plaintiff has to do it. What about the other office objections?
Production of value.
What is the suit for? The non-production of the copy of the valuation slip. Office objection regarding non-furnishing the valuation slip is overruled for the present. Is the appeal for admission.
Number 12. Yes.
This is a memo. The counsel for the appellant submits that the dispute within the parties is settled, and a memo to withdraw the appeal was filed on 30th of March, 31/3/2022. The submission based on record. The appeal is dismissed as withdrawn. Yeah. You are. That's it. Dismiss as withdrawn. Counsel for the appellant submits that the DCF is paid on 14/2/2020. Office to check and verify.
14. Vishnu Shetty.
Go for the defendants. Go for the plaintiff number 2. You don't have any document to establish that. 4 weeks time is granted to file proof of the death of plaintiff number 1 and 3, failing which the appeal shall stand abated.
Number 15, Prasad Beer.
Please, Parni, what are the preliminary objections? Please comply with this.
Not made as a party. Respondent number 1 is a bank, not the party recovery. Principal borrower, respondent number 1 and 2 and 3. They issued as a guarantor. The appellant is issued as a guarantor. I never stood as a guarantor, and I filed a counterclaim to return all documents. My counterclaim has been allowed. Against that order, may not they filed an appeal to the they are not made as a party. Respondent number 2 and 3. They are the necessary party. That's the reason not in the OS they are made as a party. I made as a respondent number 2 and 3.
The office, the note furnished below the constitutional as to why the respondent number 2 and 3 are arrayed as parties in the appeal is accepted. What about this acceptance of type copy of written statement? What is this?
Court will discuss the Malata to show that Malata counterclaim will be supported.
The type copy of written statement. What do you mean by that? The type copy of the written statement furnished by the counsel for the appellant is accepted. But what are the other objections?
Court will discuss Malata in counterclaim Malata is subjected to I felt that court will also.
If accepted, receipt to be made good as per section 49. How much court fee was paid?
Last. And the first appeal also not
The Learned Counsel submits that a sum of ₹50 was the court fee paid on the counterclaim in the written statement, and therefore the appellant has paid the same court fee. Office is directed to check and verify. What is this complaints on office objections on IA? Here IA. There's some application that you have filed. Huh? Then application name. Office objections raised on IA. Overruled for the present. Is the appeal for Partition. If all office objections are complete. Which time is granted to pay, process and other requisites to issue notice to the unserved respondents and to take steps in respect of deceased respondent number 6.
15, number 15.
Yes, ma'am. 2 weeks time is granted to take to pay, process and other requisites to issue notice on IA 123 of 2021. What about non-amendment? Amendment ಮಾಡಿ madam. Please amend it. Counsel for the appellant. What is this IA 123 of 21? Yeah, who appears for us? Tell us some respond number 2. Is there any the VB Siddharamaiah. You bring him, madam. You please bring him. Madam Siddharamaiah. Please bring Mr. VB Siddharamaiah. pass over. Counsel for the appellant submits the process and other requisites to be paid during the course of the day. The process is paid, office is directed to verify and proceed to issue notice.
Service is awaited.
Point number 190. The appeal maintainable.
Instead of already decided property, it's scheduled property is already decided. But will remain in the matter, entire properties are remanded. Instead of leaving the other property. Property that other than all must have ancestral properties, other are self-acquired properties. Self-acquired properties already decided. Self-acquired properties do not money.
Where does the subsequent court say that the remand is only in respect of one item? Mr. The entire judgment passed in the trial court is set aside and the case is remitted back to the trial court. So therefore, that is wrong. What has to be filed? Is it a miscellaneous second appeal or a regular second appeal? How? What is decided? What is decided?
Already decided one, 2, 3, and 7, 8 are ancestral property. They are not self-acquired property.
Who has decided? Who has decided that? The trial court must have decided, Mr. The first appellate court says the entire judgment is set aside. So therefore, you should file a miscellaneous second appeal, not a regular second appeal. So what will you do? ಅಲ್ಲ ಏನಕ್ಕೆ ಬಂದಿರೋದು ಅಂತ ಗೊತ್ತಾ ನಿಮಗೆ? The counsel for the appellant submits that seeks liberty to convert this to a miscellaneous second appeal. In view of the aforesaid submission, the office objections raised regarding maintainability of this appeal is upheld. The counsel for the appellant is permitted to convert this regular second appeal as miscellaneous second appeal. Full stop. The register is directed to renumber this case as miscellaneous second appeal and assign new number. For statistical purposes, this appeal stands disposed.
Number 21.
The notice issued to the respondent number 134A to A, 4A, D, E, F, and G is refused. This notice to the said respondents is accepted as sufficient. Office is directed to show the names of the said respondents in the cause list as served. 2 weeks time is granted to take out to pay process and deposit other requisites to issue notice to the unserved respondents. 2 weeks to Saka, 4 weeks. 4 weeks time. I think make another kudi. Please deposit the process fee to issue notice to the respondent 5 to 7, 10, and 4C. Kudi.
Number 22. Sigma Proceedings.
ಅದಾಯ್ತು ಅದು ಮಾಡಾಯ್ತು. Counsel for the appellant submits that the dispute between the parties is settled and therefore the appellants may be permitted to withdraw. A memo to that effect is filed. Full stop. In view of this memo, the appeal is dismissed as withdrawn. The office is directed to return. Office is directed to refund the court fee as is permissible in law. It's still a court fee.
Right.
Next.
Glad I am representing the appellant in this case. The valuation is mentioned at page 5 of the appeal memo. Para 13. ಅದರಲ್ಲಿ ಎಲ್ಲ ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿದ್ದೀನಿ. 200 rupees ಅವ್ರು ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿರೋದು, ನಾವು ಇಲ್ಲಿ 200 rupees ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದ್ದೀವಿ.
The office objections regarding non-furnishing of proof of a regular.
Application ಅಂತಾರೆ ಅವರು.
Please wait. Non-filing of office objections of proof regarding the court fee paid before the first appeal. First appellate court is overruled. This is the appeal for admission.
Oblige.
Year 1 of 2020 is filed for recalling the order date, filed for condonation of delay of 1963 days in filing. 1963 days in filing the application to recall the order dated 27/1/2015. Though the cause shown for the delay is not satisfactory, nonetheless, since the suit is filed for partition separate possession, the delay in filing the application is condoned. In 2013 ಆಗಿರೋದು ಏನು ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದ ಮತ್ತೆ 2020 ನಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ after 5 years condoned subject to payment of cost of ₹2,000 payable to the High Court Legal Services Authority. So, in view of the above, IA2 of 2020 is allowed and the order dated 27/1/2015 is recalled. Counsel for the appellant is granted 4 weeks time to comply the office objections, failing which the appeal shall again stand dismissed for non-compliance of office objections without reference to bench. High Court Legal Services Authority. Legal Services Committee alone. Committee. HLC. Karnataka State Legal Services Authority. ACS.
For appellant, I have filed this application to be
Notice on IA 2/3 of 2022. Mr. Somshekaraya, ಯಾವ್ದೋ ಒಂದು ಕೇಸ್ ಇದೆ ಅದನ್ನ ಬರೋದೇ ಇಲ್ಲ ಅಂತೀರಿ ನೀವು.
ಅದು ಇನ್ನೊಂದು I was on leg in another court malad. The meanwhile it is serial number
Passed over. ಬರ್ದೇ no, it is passed over. ಬರ್ದೇ ಇದ್ರೆ ಅದು other side has filed an application to recall the order of accepting the compromise.
Malad, I have contacted the party, but they are not responding. Malad, court notice.
If they are not responding, and they will recall the order. If the party who is affected by the order is not made a party to the compromise and some collusive compromise is reported to the court, court will recall the order.
Avರಿಗೆ notice, election may kindly order notice to the.
No. Notice alla kodakagudu. It says no, sorry.
Please, man.
So the applicant says, the applicant says that his property is included in the collusive compromise. If that is so, the matter will have to be heard. If bandre banni bitre bidi application to dispose agutti ಇವತ್ತು. Yes. Next.
It may be allowed and notice may be ordered.
For the appellant,
take a call. The passover agide. You take a call. What you want to do?
Please, man.
that's one. Represent the appellant in this.
Year 1 of 22 is filed. Year 1 of 22 is filed to bring the legal representatives of the deceased appellant on record. Sorry, IA 1 of 22 is filed by the applicants who are the legal
Yes, my lord.
representatives of deceased appellant number 1. Full stop. Since the cause of action is survived the death of the appellant number 1, IA 1 of 22 is allowed. What about IA 2?
My lord, so IA number 2 is for posting the way of file. To consider the
IA
lapse
2 of
application.
51 is filed for bringing legal representatives of deceased R1.
Please.
Notice
Please, my
hogidiya.
lord. No, my lord. Notice has been not ordered.
Issue notice on IA 2 of 2021. What about this IA 1 of 21? IA 1 of
That
21
is
is
the
for the
not
appellant and the same rejected. What is this complaints of office objections raised on memo?
memo
Who has
is
filed
the respondent number 1 advocate, my lord.
What is the office objection? ಏನ್ ರೀ ಅದು?
ಅದರಲ್ಲಿ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ಹೆಸರು ಈರಪ್ಪ ಅಂತ ಹೇಳಿ ಬಟ್ ಅವ್ರ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ವೀರಪ್ಪ ಅಂತ ಇದೆ. ದಟ್ ಹಸ್ ಬೀನ್ ಕ್ಲಾರಿಫೈ.
The office objections raised on memo does not survive for consideration.
My lord, IA number 1 of 15 is pending
IA 1 of 15 is for what?
for stay
Stay.
of the
First notice ಕೊಡಿ, ಇದೆಲ್ಲ ತಗೊಳ್ಳಿ.
my lord, they are changing the records in their names, my lord.
ಈಗ ಚೇಂಜ್ ಮಾಡಿಸ್ಬೋದಲ್ಲ. It's not a permanent change, mister. The revenue records
Permanent. They are
It can-
trying to
it can
solve the
change.
property also. Please, ma'am. Sorry. Please,
can
ma'am.
be changed.
Please, ma'am.
Yes. ಶುರುವಾಗಿದ್ಯಾ? ಇದು objection. Purport. IA 1 of 19 is filed for condonation delay of 355 days in filing the application to bring the legal representatives of deceased R16. The counsel for the legal representatives of respondent number 16 has not objected to this application. Nonetheless, the cause shown for the delay is accepted since IA 1 of 19 is allowed. Since the cause of action has survived against the legal representatives of R16, IA 2 of 2019 for setting aside the amendment is allowed. In view of the above, IA 3 of 19, which is filed to bring the legal representatives of deceased R16 is allowed, and the legal representatives are ordered to be brought on record. What about the next topic? Notice ಹೋಗಿದ್ಯಾ? ಬರ್ಕೊಳ್ಳಿ. IA 7 of 2019 is filed for condonation of delay of 164 days in filing the application to bring the legal representatives of deceased R15. The cause shown for the delay is accepted. Hence, IA 7 of 2019 is allowed. Consequently, IA 8 of 2019 for setting aside the abatement of the appeal is allowed as the cause of action has survived against the legal representatives of R15. In view of the above, IA 9 of 19 is also allowed, and the legal representatives of R15 are ordered to be put on record. The complaints of office objections raised on ಇದು ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ? 22 ಅಂತಿದೆ. ಬರ್ಕೊಳ್ಳಿ. IA 1 of 2022 is filed for condonation of delay in filing the application to bring the legal representatives of proposed respondent for late, accepting the cause shown for the delay. IA 1 of 22 is allowed. ನೀವು ಪ್ರಪೋಸ್ ಯಾಕೆ ಅವ್ರ ಹೆಸರು ಹಾಕಿದ್ರೆ ಆಯ್ತಲ್ಲ. Why did you file one more application? ಆಯ್ತು, ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ರೆ ಆಗಿದೆ. Consequently, IA 2 of 22 is also allowed. And IA 2 and 3 of 22 are allowed. Counsel for the appellant is directed to amend the cost rate and partition amended cost rate. A memo is filed to treat the respondent number 9 and 10 as the legal representatives of R8. In view of the memo, the respondent number 9 and 10 are treated as the LRs of R8. Counsel for the appellant is directed to make appropriate entries in the cost title regarding indicating the death of R8. Notice ಹೋಗಿದ್ಯಾ? IA 4 of 2019 is filed for condonation of delay in filing the application to bring the legal representatives of deceased R12. The notice of this application was served on the legal representatives of R12 who are not opposed to application. However, the cost found for the delay is accepted, hence IA 4 of 19 is allowed. Consequently, IA 5 of 2019 for setting aside the abatement of the appeal is allowed, and the abatement of the appeal is set aside. View of the above, IA 6 of 19 is also allowed, and the legal representatives of R12 are ordered to be brought on record. Counsel for the appellant is directed to amend the cost statement permission amended cost. But in the delay ne condone agilwala. Any objection? Any objection, Mr. Who appears for it?
Not served any copy, sir. A copy is for Marika. Why what color can? It can not continually collection.
I think 9 ದಿನ delay gain of objection. Stay ಇಲ್ಲಿ condonation delay. Why don't you keep your eyes and ears open, mister? Condonation of delay ಬಗ್ಗೆ ಹೇಳಿದ್ರೆ temporary injunction ಬಗ್ಗೆ ಹೇಳಿ. I asked you for condonation of delay. You are arguing for temporary application injunction. IA 1 of 16 is filed for condonation of delay of 9 days in filing the appeal. None of the respondents have opposed this application. Since the suit is filed for partition separate possession, the delay of 9 days partition separate possession, the caution for the delay of 9 days is accepted. Hence, IA 1 of 16 is allowed. It's the appeal for admission. Friday. Yes, on Friday. Appeal is admitted. Since the appeal is admitted, IA 1 of 22, which is filed for extension of the interim order, is allowed. And the interim order granted on One to 2019 is extended till the disposal of this appeal. No, there is no question of fast tracking any appeal. Everything has to come as per seniority. No fast tracking.
29.
Issue notice on IA 1 of 20, 1 of 20, 2 of 20, 3 of 20, 4 of 20.
13. That is not a percentage. That's a percentage to take hands on so that
First, IML ತಗೊಳ್ರಿ ಆಮೇಲೆ hands. Any respondents? In addition, the learned counsel is permitted to take out hand summons. Yes.
Number 30. S.V. Prakash.
Yes, S.V. Prakash. Mr. S.V. Prakash. Issue notice on IA 1 of 21. Issue notice on IA 1 of 20. Issue notice on IA 1 of 19.
33, I appear for the appellant. My lord, IA 1 of 2019 has been filed seeking delay of
for
149.
your lordship, 33.
Please wait, madam. Somebody is submitting. One after the other. Yes.
Please.
Wait.
1497 days delay, my lord, in filing the appeal.
Ah.
The reason, my lord, is after the disposal of the regular appeal, the appellant had been advised to file another suit. Accordingly, he filed another suit in OS number 355 of 2015.
Madam, any objection for the continuation of delay?
Yes, your lordship. Kindly, I pray time to file objection, your lordship. I had applied for some copies, your lordship.
What copies, madam?
Certified, actually, they have filed a 1500 days delay is there, your lordship. You
Yes, but I
actually,
can
this case has been, your lordship.
I can see that there's a delay of 1500 days.
Yes, your lordship. I want to file some of the certified copies I had applied in lower court, your lordship. So far, I have not got the copies, your lordship. Hence,
for
I
the
pray
delay-
time 2 weeks.
For condonation of delay, what certified copies do you need, madam?
Your lordship, this particular, this appeal has been filed for the Sridhana property. This is the Sridhana property, your lordship.
Go on
Already,
merits, madam. Don't go on merits. He says that he was supposed to file a regular appeal. After the disposal of RA, he says that his lawyer had advised him to file one more suit, and thereafter he filed one more suit. And now he realized that without filing a second appeal, he could not have filed another suit. So therefore, he says there's a delay. They accept it or not. Some cost will be imposed and the delay may be controlled.
cost may be applied, your lordship.
The counsel for the IA 1 of 2019 is filed for continuation of delay of 1497 days in filing the appeal. It is stated in the affidavit accompanying the application that withdrawal of suit and then
My lord, I have filed another suit. There are some formal defects in the present suit. And hence, my lord, I have to rectify the formal defects. My lord, I have filed an application seeking.
stated in the affidavit accompanying the application that after the judgment and decree of the first appellate court, the appellant approached the respondent and other members of the family, demanding 1/3 share in the suit property. However, the respondent and other family members did not partition. On the other hand, they tried to commit acts of waste for the suit property, and therefore the appellant was advised to file a fresh suit seeking partition separate possession of his 1/3 share in the suit property by arraying all the members of the family. Full stop. The appellant thereafter filed OS number 355 of 2015 for partition and separate possession. The said suit, he sought for interim injunction, which was dismissed by the trial court 19/3/2016, against which he filed May 17 of 2016 before the senior civil judge Chandraya Patna. The appeal was allowed on 16/9/2017. He therefore contended that an order of injunction is passed in OS 355 of 2015, restraining the members of the family from alienating the suit property. Notwithstanding the said fact, the defendants in OS number 355 of 2015 went near the suit properties in August 2019 and cut the standing trees and tried to level the suit property. They also removed the grave stone, the tomb of his father, situated in the suit property. The appellant was advised to file a second appeal challenging the judgment and decree of the first appeal. Judgment and decree passed first appeal, and due to this, the appeal could not be filed in time. So the cause shown for the delay, but yet since the proprietary, since the rights of the appellant, the property is challenged, the delay of 1497 days in filing the appeal deserves to be condoned, subject to payment of cost of rupees. How much?
I leave it to my lord.
5,000.
10,000 will be better.
Madam, I also wish I could pay you 50,000 rupees.
As the court pleases, Your Lordship. As the
50,000
much
payable to
obliged,
the-
Your Lordship.
within a period of 1 week, within a period of 4 weeks from today. Yes. What is this IA 3 of 21 for withdrawal of?
My lord, there is another suit that I have filed, my lord, in OS number 355. Where, my lord, I have brought, in fact, along with this application itself, I have produced the plaint.
If you want to withdraw this suit, then what is the purpose of filing the second appeal?
Now, this suit, my lord, what happens is there are certain findings, though all parties and properties are not there, that will come in my way, my lord, in I prosecuting that suit. And hence I'll withdraw the present suit.
Withdraw this suit, Mr.
Pardon, my lord.
This appeal arises out of OS number 326 of 2012.
Yes, my lord, please.
If you want to withdraw this suit, then what is the big fun in filing a second appeal?
The reason is, my lord, this will stay, the findings will stay, and that will stare at me, my lord, in the form of res judicata for my subsequent suit. Now,
Yes.
that is the difficulty that I'll face. Because all the parties and properties are not
No,
included.
but these findings will remain, even if you withdraw the suit, the findings will remain.
What I'm proposing, in view of the formal defect, what I'm proposing is to withdraw the suit itself. Then, my lord, only suit that would be in existence is the subsequent
Correct.
suit.
If there are any findings regarding your character, regarding your status, regarding your claim to the property, this will always remain.
That would not, perhaps, my lord, in view of this fact that I'm seeking the withdrawal of the very suit itself, not just the appeal.
Decide whatever you want to do.
Please.
Don't cut your legs.
Submission, Your Lordship.
The appeal for admission.
Submission, Your Lordship.
Great.
Yes, madam. Yes, madam. Muthu Lakshmi.
Your Lordship, regarding your withdrawal of suit, this is not. Yes, Your Lordship.
Madam, let the matter
Your
come up
Lordship,
for
they are
admission,
not
madam.
only this.
Let the matter come up for let the appeal come up for admission. We'll decide it at that time.
Much obliged, much grateful. Much obliged.
So for what, madam? Along with objections. Yeah, temporary injunction here.
Explaining well, not to put up any restriction. Respect to item number 9. The appeal is also.
The application is filed by you.
Really, I will file a suit for partition against my father and the appellant in the right of election. The suit came to be declared.
Yes, madam. Pass over. Pass over. Issue notice on IA 1 of 21. Notice. Settlement. Agilva. Yes.
In fact, my lord, I did not get any offer from their side. So the settlement, my lord, may not come through.
ಹೌದಾ? ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. What instruction, Mr.? It's already heard. The appeal was heard, isn't it?
Please, my lord, it was heard because.
ಆಯ್ತು, whatever it is. Huh? So the appeal deserves to be dismissed then. Settlement ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ, otherwise you have to pay it through your notes. So, what was the settlement that was offered? Suit of the plaintiff is dismissed. Why was the suit dismissed? Correct, but why is this suit for partition dismissed? Relationship is admitted. Why is the suit dismissed? When was it? When was the partition? 19? How is the partition? Is it a oral partition? Palupati, is it Palupati proved? No. Have you proved the partition, Mr.?
Lord, please, my lord, what happened was before the land tribunal itself, we had made a mention about the panchayat, and accordingly, my lord, father got certain properties, and it has been documented at an earliest point of time. And as per the said partition, my lord, the father got certain properties, which he executed a will. Daughters accepted it and have even made alienations according to the said will. Now everything has been acted upon, and there is no.
Where is the will? Where is the will?
Bill, my lord, has been marked as exhibit D7. I mean D9.
D9.
Adi adhikara register and bardidare, but that is actually the bill. Wrongly, it has been described there.
Yes, yeah, ದುಡ್ಡು ಗಿಟ್ಟು ಕೊಟ್ಟೇನೋ
ಅಲ್ಲ, ಅವ್ರು ಏನಾದ್ರೂ ಹೇಳಿದ್ರೆ ನಾನು ಖಂಡಿತ ಮಾತಾಡಿಸ್ತೀನಿ. ಅವ್ರು ಏನು ಪ್ರಪೋಸಲ್ ಕೊಡ್ಲಿಲ್ಲ.
ಆಯ್ತು, ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಏನಾದ್ರು ದುಡ್ಡು ಕಾಸು ಬೇಕಾಗುತ್ತೆ, ಎಷ್ಟು ಬೇಕು ಹೇಳಿ. ಎಷ್ಟು ಜನ ಇದ್ರ ಸಿಸ್ಟರ್ಸ್? How many sisters are there? Why don't you pay some?
My lord, Chinnamani is the only plaintiff, and she is the only.
Some ex gratia.
ಅವ್ರು ಏನು ಕೇಳ್ತಾರೆ ಅದನ್ನ ನಾವು ಹೇಳ್ಬೋದು. There is nothing like saying no.
No, but that is right. See, if you have taken the father's property and if you admitted everything, so ದುಡ್ಡು ತಗೊಂಡು close ಮಾಡಿ. Better you take some money and get a dismissal instead of 10 lakhs. 10 lakhs ಕೊಡ್ತೀರಿ?
10 lakhs ಅಷ್ಟು ವ್ಯಾಲ್ಯೂನೇ ಇಲ್ಲಪ್ಪ.
ಇದಿರಲ್ಲಪ್ಪ. All the brothers.
Now the rest of them, my lord, are happy. They have all sold their properties, my lord, which they got under the will. There is no dispute. Ivrunu kuda ivrige bandiro property ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ. In ಏನಿದ್ರೂನು ಒಂದು
ಕೊಡ್ತೀರಿ ಹೇಳಿ, ನೀವೇ ಹೇಳಿ.
My lord, I'll seek some instruction.
Sooner the better. How soon can you get the instructions? Friday.
Friday, very good.
10 ಲಕ್ಷ ಅಂತ ಹೇಳ್ರಿ. Put on me and say that 10 lakhs is what the court is expecting. Please. Two of them can put in 5 lakhs each and just close the matter. And she is also suffering from some disease. She is ailing.
Very well.
ಕಷ್ಟ ಕಾಲದಲ್ಲಿ ಏನೋ ದುಡ್ಡಾಗುತ್ತೆ.
ನಾನು ಹೇಳಿ.
ಸೆಟ್ಲ್ ಆಯ್ತಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅದು ನೆಕ್ಸ್ಟ್ ಡೇ.
ಅಲ್ಲೇನಂದ್ರೆ 53 ಒಂದ್ ಕಡೆ 59 ಒಂದ್ ಕಡೆ 59 53 ಅವ್ರು ಬೇಕೇ ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ಪ್ರಾಪರ್ಟಿ ಕಡಿಮೆ ಇರೋದು ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಬೇಕೇ ಬೇಕು. ಆಯ್ತು ಅಲ್ಲಿ ದುಡ್ಡು ಅದಕ್ಕೆ ನೀವು ವ್ಯಾಲ್ಯೂಷನ್ ಅದಕ್ಕೂ ಒಪ್ಕೊಂಡಿದ್ವಿ, ವ್ಯಾಲ್ಯೂಷನ್ ಕೊಡೋದಕ್ಕೂ ಒಪ್ಕೊಂಡಿದ್ವಿ. ಅದು ನೀವು ಕೆಟ್ಟ ಡೀಲಿನ ಅಮೌಂಟ್ ಏನಂತ ಅದು
ಕ್ಯಾಶ್ ತಂದ್ಬಿಡಿ ಇದ್ರೆ
ಕೊಡ್ತೀವಿ. ನಮ್ಗೆ ಸಮಸ್ಯೆ ಆಗ್ತದೆ.
ಸರ್ ನೀವೇನ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತೀರಾ? ಕ್ಯಾಶ್ ಮನೇಲಿ ಇಟ್ಟಿರ್ತದೆ ತಾನು, ಕೊಡಿ ಅದು. No, it will be recorded in the court, Mister. You have an official document that you are paying money towards the value of the checks in cash. ಮಾತಾಡಿ 50 ಕ್ಯಾಶ್ 50 ಚೆಕ್ ಆತರ ಏನೋ ತಗೊಳ್ಳಿ. 50% ಚೆಕ್ ಕೊಡಿ, 50% ಕ್ಯಾಶ್ ಕೊಡಿ. ಕೊಡಿ, ಏನೋ ಒಂದು ವಯ ಮೀಡಿಯಾ ಮುಗಿಸಿ. ಇಷ್ಟೇ ದೂರ ಬಂದಿದ್ರ ಕೊನೆಯಲ್ಲಿ ಯಾಕೆ ಒಪ್ಕೊಂಡಿರಲ್ಲ? ಯಾವ ಅಪ್ಲಿಕೇಶನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ ಮಾಡಿ ಐ ಅಲೋ ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್. Yes, password.
Pending admission, this may be the chances of settlement, the right is going to the court.
ರೈಟ್ ಬರ್ದೆ ಗಂಡ ಬಂದ್ರೆ ವಕಾಲತಿ ಗಂಡ ಹಾಕ್ಸಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
And even the third appeal system, she told me she doesn't want any share and she has remained out of the group. But I present not pending admission notice will be issued.
Notice regarding admission.
Number 39, 30
Notice regarding it. Notice regarding it. Issue emergent notice. Mr. Manja Reddy. Yes, sir.
I request you, Lordship, may kindly put up RSA records so that it.
Let us see what is the.
Yes,
what is the error?
Let the petitioner was the appellant before the second appeal. Let they have purchased the blood 3.5 quintas from one Srimati Gangamma. But what happened? Blood there was already a suit pending against Gangamma by the respondents 1 and 2, 1 to 4. After the dismissal of the suit by default, the petitioner has purchased this property.
Yes.
Thereafter about 4 years, Note the petitioner was impleaded thereafter that we have come on record, and the suit was contested and suit was decreed. Against which the appeals were filed. Appeal also came to be dismissed, and the second appeal was filed. My respectful
What was
submission
the
is
earlier suit filed for?
specific performance.
Yes. You are a
that is the
party there. The petitioners herein were parties in the suit for specific performance.
No, we are not parties at the first instance.
Correct,
But
sir.
yes, after the dismissal of the suit, we had purchased, we had no knowledge
as
about.
So as of now, you were implicated in the suit.
Yes. I was implicated by the plaintiffs. Thereafter, it was passed.
Yes. So what is wrong in this?
Let the disarm report let passed orders solely on the ground at para 14 of the judgment, page 19. Now, with clarity, it is to be mentioned that there are two regular appeals resulting from RA 113 of 2006, that is preferred by purchaser Dastagir Khan, that is the petitioner herein, who are the second and third defendants in the client. So far as BL Krishnamurthy is concerned, there is no appeal. Gangamma is first defendant appellant in RMR so and so. So, Milad, the appeals were prepared, both the appeals made by my vendor and myself. And thereafter, my vendor
is Krishnamurthy.
My vendor is Gangamma.
Gangamma.
Yes, Krishnamurthy was the Milad plaintiff. Against Gangamma
filed an appeal.
Appeal was first, second appeal akil.
They are not filed.
But they have not filed. So on that ground, that the suit, this appeal has been dismissed.
So why do you? What is the mistake in the order?
The list as per section 52 of the Milad Transfer of Property Act. The suit commences from the date on which the impleading applicants, that is the petitioners, were impleaded. But as held by the Supreme Court in 2008. So the only decree has been passed against the the vendor Gangam. So I am not entitled to, I am in possession of the property ever since from the date of purchase. 1994 in the I am in possession of the property.
Yes.
Therefore, the
No, but this is a ground of, sir, this is a ground of an appeal.
That was not considered by the even the second the Gangamma, since she has not challenged, since she has sold the property, she has not preferred the second appeal.
Correct, sir.
She had no interest. Yes.
What is your grounds of appeal for the first appellate court, the second appellate court? What were your grounds of challenge?
I think if Lordship kindly put up those records.
What basis to challenge the decree of special performance?
On the ground that the the question of law was raised was whether the judgment and decree passed by contrary to section 68 of the Evidence Act, as the attesting witnesses were not examined to prove the execution of the agreement, because that was denied by my vendor also in the suit. Another one, whether the pendants is applicable, list pendants is applicable to the appellants under section 52 of the Transfer of Property Act for having purchased the scheduled property from the first defendant when there was no judicial proceedings pending as on the date of execution of the registration of the sale deed in the year 1994. And also whether the trial court is justified in decreeing the suit only against the first defendant in the absence of cancellation of the sale deed executed in favor of the petitioners.
Therefore, this is a ground of appeal, sir, not a ground for review. Appeal is correct, correct. But is it a ground for review?
That was not considered under the, that is my respectful submission.
Office granted to put up RSA, that the records in the
May I request for order notice, my lord?
no, let the first record body.
Sorry.
Another two filed by the authority as part of the funding. That is where 22. But 2.2, I was in fact, there is conflicting two different ends and two ones I will have taken a notice from me. That was last night, yesterday night, he requires time to get an error. Let us see what one is a proposal, one is a son. I will unknowingly have to look at two different persons taken two different offices.
Separate ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
Separate ಆಗಿತ್ತು. So, ಎಲ್ಲರೂ
RSA 825 is against which order?
common order against common order means
Common order separate appeals file ಮಾಡಿದ್ದೀವಿ.
And the partition by the plaintiff and the defendant. Parties are the same in both decisions. The plaintiffs are the defendants and defendants are the plaintiffs.
That's 826. Please wait. Yes.
Then OS number 102 for 2007. One right to the appellate. Before the last, the respondent, May 10 and 11, Kerala brothers. Against Millard, the respondent wants to go. A partition of separate position is the land and cover.
102 of 2007 is for partition.
Yes, both is for partition.
102 and 102
by 2007. And my last, OS number 74 by 2009. The OS 74 by 2009 my last was filed by the latter of the first respondent.
So please refer to the trial court cost statements. Trial court cost statement.
Please. The plaintiffs in OS number 102. They are filed for partition and beyond is the land family property. It is the respondent, that is.
Sir, again, don't go back to respondents, sir. I don't know. ಎಷ್ಟು ಸತಿ ದಿನ ಕೋರ್ಟ್ ಇದೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿ I don't know. Please stick to the trial court cost because you say plaintiff, then you say respondent, then you say respondent in second appeal, respondent in first appeal. Please stick to the trial court cost statement.
Please, you ask me kindly take this judgment. Yeah, please.
Yeah.
Yes, sir.
22-4. These are Prabhakar, Bhaskar, and Sujata. They are all the sons of the first respondent. Suit for partition against her mother, first dependent, and their brothers, dependent number 2. Remittal. And his 2 daughters, the dependents 3 and 4. There are the dependents 3 and 4. By the OS number 74 for 2009. The area and against their father and also the dependent.
You can count the suit.
Yes, counter both for partition. Both for partition and the counter. That family property. There was no partition, but at a state. Then my lad, the dependent, first dependent contested this. Saying that my lad, there was a alpha, in that there was a partition was affected. And my this husband, I think the first dependent husband, and after his death, my lad, she has executed, my lad gifted in favor of the first dependent.
What are the nature of the properties?
Well, they are all joint family properties. Both the family, all the joint family properties. And we filed suit for partition. And trial court may not dismiss the suit. On the ground may not, there is already a partition. All the partition produced money. Trial court. They are asked to do any conflict before the trial. And then you dependent one and suit also was discussed and same ground. They were close together. And a common judgment was passed. Discussing both the suits. Against Malad, 3 appeals were filed. Malad, 1 appeal was filed by the first plaintiff. Malad, that is the appellant for the market. And another appeal, Malad, was filed by the defendant. Plaintiffs 2-4. In area number
38.
yes, please. And when another appeal was filed by in area 131, that is dependents
74.
All when that comes together and the trial court discusses. My responsible sufficient both disputes, one of the dependents 2 and 3 who have filed the suit against their father, their contention is a joint family property. Our contention is also that it's a joint family property. The trial court may not taken the same ground that is in the absence of the father. The first defendant could not have executed Malad guilty in favor of the first son. Because it's a joint family property, all the plaintiff and defendants are. This matter was posted.
Palupatti improve agide. How is it?
First defendant.
How is the Palupatti prove?
Palupatti has not been proved at all.
And how did the trial court dismiss the suit?
Yes, they take a lot of attention to the reasoning of the trial court.
First, please look at the issues.
Yes,
The dependent 4. Who is this Kempamma? So we are question, huh?
I have other equal tenants here.
The defendant number 4 proves that suit items 2 to 5 and 11. Half portion of item number 11 was given to the first defendant for her maintenance by her husband, Late Daseguda, in the presence of Panchayat Das. She is in possession of the said properties. Further proves that 31 guntas in item number 2 were sold to Lingamma as per the sale. Through the assets of the plaintiff, Khata of item 1610 was changed in the mother, Srimati Jayamma, and instead of further festival in the number 4 as per the Manjula, wife of B.D. Ravi. In the Palupati issue in the yes, Mr. Where is the issue?
But it was dismissed on the ground of enlargement of the statement.
Correct. For the defendant number one to get this property, it is the father who must have gifted it.
Not that, but what happened during the lifetime, but Dasai Goda was trying to. One is Jayama and one is Nisha. But like during the lifetime of first wife, he has committed marriage is second wife. And there, like difference of opinion between both the first wife and second wife. Sumitra Mari has started to get separate. And therefore, Lord, he has orally gifted the property, that is the institutional property, Sumitra Mari. And therefore, the mutation was affected in her name.
Morally gifting. Where is the question of morally gifting?
But 1970, mutation happened.
Morally gifted in the book. Correct. Well,
Settlement money to the
I doesn't improve it.
that is why. By way of a brief document, 1970 document, 1973, mutation was affected in the name of Sumitra. Now, Lord Sumitra was her name is located both in the cultivated column and also in the owner's column. And she was entitled to property as an absolute owner. Now, Lord, both the courts are writing the to pay, and this is.
Let us see then section 14.
It is extracted in paragraph integrated 22.
What do you mean by the word whether acquired before? Acquired and then acquired should be in the manner known to law.
The property of the female here, we have absolute property. Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as full owner thereof and not as a limited.
Acquired and then in the manner known to Transfer Property Act.
That has been indicated in this court, my lord. Paragraph number 29 of the first subject court. Paragraph number 29 of the first.
Yes, please read.
May I just read that question now? Now the question is whether-
Para?
29, paragraph 29. Implement
Page 22. There is issues.
No, my lord. First subject court, sir. First subject court.
Yes, please.
Now the question is whether change of data itself is sufficient to acquire the title over those properties by late Sumitra received. Under section 14 of the Hindu Succession Act, any property possessed by a female Hindu will acquired before or after the this act shall be held by her as a full owner thereof, not as a limited owner. From the revenue records produced by both the sides and oral evidence of DW1, it is proved that from 1972-73, during the lifetime of Sumitra, she has been in possession of acquired properties transferred to her name and her evidence to the effect that a husband transfer them in lieu of maintenance is acceptable. As a deputy, Dr. Dora had undergone second marriage. Therefore, under section 14 of the Hindu Succession Act, Sumitra became a good owner of the property transferred to her name during the lifetime of Class A owner. But it is not the case of the plaintiff that during the lifetime of Class A owner, he has challenged such transfer. During the course of trial, the specific question was put to Degree 1 and 2. That was it is
have the case of the case that where Rasayoga and old landed property yearly ceiling, year ceiling,
More than ceiling.
therefore, the real suggestion put to DW1 and 2 are not sufficient with 3 levels of DW1. That in view of making it Rasayoga render or making a review because of landed property. I share in possession of those properties. During the course of class examination of DW1, he has admitted that during 1995, they have sold property bearing number 19 assessed to number 60 in favor of one Mahadevu as per safety data also. It is an admitted fact that the safety was executed by DW1 and his brothers and his mother, but either defendant number 1 or 2. It is also admitted fact that defendant number 1 and 2 have sold portion of survey number 54 and 25/3/1995 in favor of Indama. For that, either the plaintiffs or their mother have put their signature. Both the transaction was not challenged by each party. On the contrary, in the same deed, as for exhibit B63, Sumitra defendant number 2, that is particularly as his first person. In exhibit P12, the plaintiffs themselves have mentioned that particularly have gone in adoption to Sumitra. Exhibit P12, mutation entry was effected during the 2001, much prior to filing of these two suits. As per exhibit P11, also it is mentioned that there is a consigned property where the first defendant has two properties. Except the property given to first defendant for maintenance by Rasayoga, no other properties were given to defendant immediately. But from going through the documentation to both the sides, admissions given by DW1 during the course of transaction that there was a partition between the plaintiffs is clear that even though defendant number 2 is a biological son of Dayamba and Rasayoga, and he grown up with Sumitra and they are
Consider or for records. Substantial question of law which arises for consideration in this appeal is whether the revenue documents creates whether entries in revenue documents created a title. Entries in revenue documents resulted in double inner comma acquisition bracket close of title by the defendant number 1, and therefore she became the full owner of the suit property by virtue of section 14 of the Hindu Succession Act 1956. Next, whether the defendant number 4 in OS number 102 of 2007 had proved the lawful gift alone. Alleged settlement of suit items 2 to 4. R4 defendant number 4 ge. Defendant number 4 ge 2 to 4 dane.
Sumitra is item number 2 to 5 and
correct Sumitra munge. What about D4? D4 ಏನೋ gift ಮಾಡಿದಾರಂತಲ್ಲ. This is the only question.
That is all.
Good, yes. The drawing up of final decree is stayed. Suit has been dismissed. The amount or the amount of compensation that is deposited in LAC number.
LAC number 3.
LAC number so and so.
NSAI, LAC, PC, SRI, PELJ, partial for 2019.
Before
the special land acquisition officer.
Before the
National Area Authority.
Sir, total deposit el madidar sir. Disposal of these appeals, the compensation payable in respect of the acquisition of survey number.
Yes, survey number 9, survey number 499 and 500.
499 and 500 of
Balagola village.
Elegola village,
3,180 and 2,500 square meters.
Elegola village measuring 3,000,
3,180
180,
and 2,503 square meters.
2503 square meters estate will not be dispersed to any person. Yes. Next. ಅದೇನು ಹಾಕೊಂಡಲ್ಲಿ ಎಫ್ಡಿಗೋ ಗಿಫ್ಟಿಗೋ ಶಿಫ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ಸುಮ್ಮನೆ ಯಾಕಲ್ಲಿ. ಆಯ್ತು ಸರ್, ನಾನು ಹೇಳ್ತಿರೋದು ಸುಮ್ಮನೆ ಅಲ್ಲಿದ್ದರೆ ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಬರೋದಿಲ್ಲ. ವೈ ಡೋಂಟ್ ಯು ಗೆಟ್ ಇಟ್ ಡೆಪಾಸಿಟೆಡ್ ಸಮ್ವೇರ್? You are not interested in this particular survey number. Right. Yes, next. Yes, please.
The agreement is dated 23/1/2003.
23/1/2003.
Lord, the subject matter of the agreement is 2 acres 21 guntas of land in survey number 131/4 of Sonu village.
Agree.
Yes. Consideration was 1,50,000. 50,000. Lord, advance amount of rupees 1,40,000 is paid in days. Subsequently, a sum of rupees 8,000 was paid. The Shara was recorded on 15/3/2003. Another Shara was recorded with regard to the balance 2,000. However, it was not signed. Lord, suit is filed on
What is
3/7/2000.
What is the time fixed for the agreement conclusion?
Time is not fixed.
Time is not fixed.
But the defendant has filed the written statement. Totally denied it. Entire transaction is there. But the trial court recorded the evidence of the claim on 8/12/2006. PW1 was examined and adjourned for cross-examination. And on 12/1 it was adjourned, and 9/2 it was recorded, my lord. The defendant number 1 and her counsel are absent. Therefore, it was posted for cross-examination was taken as name, my lord. Then it was posted for defendant's evidence. And the subsequently defendant evidence was also taken as not defendant has not reduced evidence. Therefore, the matter was posted for arguments and.
Whether defendants 2 and 3 had also participated in
No,
the.
they as against them, but they suit is
No. So far as defendant number 2 and 3,
they are not concerned.
they are signatories to the agreement.
Clear.
Makkalalva, they are your children.
They are another purchaser.
Harish and Pushpa, they are children.
They are not concerned. Therefore, the suit is dismissed again. Lord, before the first appellate court, I had filed in a case 4 applications. One to raise additional grounds. 3 applications were not for receiving the documents. Lord, I have produced documents to show that at the time of cross-examination and the subsequent stages, my husband, he was assaulted and near fatal injury was inflicted on my husband. He lost his leg and he was admitted to the hospital. But therefore,
How is that relevant?
but the opportunity for reading further evidence is what's that. But that document was produced by me before the appellate court. The appellate court, my lord, the lordship is the reasoning. My lord,
Page 42.
Here we let the trial begin afresh. ಆಯ್ತು ಏನ್ ನೀವು ಹೇಳಿದ ಕಂಡೀಷನ್ ಹಾಕು ಇದ್ ಮಾಡೋಣ. Let there be clear opportunity.
There are 3 other suits now. One filed by one Harish Kumar that I have produced, and another filed by the wife of the lady for himself.
With respect to the same property.
Same property.
These are all the suits filed against them.
No, why suit?
To defeat the claim of the client.
No, but your wife has filed one more.
We have entered into another agreement, quite possible.
ಏನೋ ಗೊತ್ತಿಲ್ಲ, ನೀವ್ ಹೇಳ್ಬೇಕು ನಿಮ್ಮ ಹೆಂಡತಿ ಏನಾಗ್ತದೆ.
Entering into various agreements.
Correct, with your own wife.
All said and done. The defendant personally appeared before the court.
Correct, sir, but
The case was posted for evidence of PW1.
Same property.
Same cross-examination of PW1. Subsequently, they were to participation.
actually we'll put him on terms. We'll put him on terms, let him file his written statement file ಮಾಡಿದಾರಾಗಲಿ. Let him adduce his evidence and let him argue ಮಾಡಿ. Decide.
He has received 1,40,000 rupees on the basis of the fees. Fair consideration is 1,50,000 rupees. 1,40,000 rupees was paid. Another 8,000 rupees was paid. Totally 1,48,000 rupees. The balance was only 2,000.
Please argue only on the question of opportunity.
Sufficient opportunity has been given by the trial court. She did not cover up the opportunity given by the trial court. When the case was posted for the cross-examination of PW, examination of PW1, she was very much present. She received the task imposed by the court for the non-appearance of the plaintiff on the previous case. She received the task. Then the case, the plaintiff was examined as PW1. Case posted for cross-examination of PW1. On subsequent days, the defendant personally did not appear and the advocate
He is not cross-examined. Plaintiff is not cross-examined.
Advocate also did not make any representation.
During those days, her husband was admitted.
The court cannot go and
What the appellate court observed, in fact, husband of D1 was assaulted and his right leg was amputated and not dead. Therefore, in spite of that, she could have attended before this.
Where is that?
Alert page 42. Internal page 23, first page. On 24/2/2007, matter stood posted for defendant. Again posted for arguments on 22/3/2007. Judgment was passed on 16/2007. The arguments and the intention of the counsel is could a court dispose of the suit so early and no fair opportunity given. According to the court, gave one opportunity for evidence of the defendant, one opportunity for argument, then the judgment was pronounced. In fact, husband of D1 was assaulted and his right leg was amputated and not dead. Hence, D1 at any stretch of imagination was not in position to that is what it is further argued that exhibit B1 shows that another contention is amount has not been repaid agreement. That means when as agreed, if the shared is not executed, courts open is to repay the amount. When that being the situation, question of seeking physical performance of the contract and directing the courts know what this is on the merits of the matter.
Right, you have any objection for remanding the case?
In fact, I talked to my client yesterday evening. He is not available.
Please argue for remand.
Localized demand is concerned. But on 23/3/1986, he was present as per the scene from the order sheet. They received the task. He posted the report on previous case of hearing. The PW1 exam was examined. the case was specifically adjourned for cross-examination of PWM. On the next case, when the case was posted, there was no representation either by the defendant or by the advocate for the defendant. Then the court has no other option except to state that the cross-examination of PWM is not. Then the man came to be adjourned for evidence of the defendant. Even on that day also there was no representation, either the defendant or counsel was made any representation before the court. The court took the evidence of defendant as the, then the matter was posted for argument. On the date of argument, advocate for the defendant filed a memo stating that the statement that has been made in the written statement be treated as the argument on the merits of. So, under these circumstances, the trial court was justified in granting the decision.
This appeal is filed by the defendant challenging the judgment and decree of the trial court and the first appellate court, by which the suit for special performance was decreed. Suit for special performance of an agreement of sale dated to dated 23/1/2003. Stop. Next paragraph, parties shall henceforth be referred to as they were arrayed before the trial court. Next paragraph. A suit for special performance was filed to enforce an agreement of sale dated 23/1/2003 in respect of certain agricultural land. Stop. The plaintiff claimed that the defendant number one had agreed to sell the suit property for a total sale consideration of ₹1,50,000 and had paid a sum of ₹1,40,000 on the date of the agreement and later paid a sum of ₹8,000. Full stop. He claimed that the balance sum of ₹2,000 was payable on the date of the registration of a deed of absolute sale. Full stop. He alleged that the defendant number one did not conclude the sale transaction even after being called upon to do so, which compelled him to file a suit for special performance. Stop. Next paragraph. The defendant number one contested the suit and filed a written statement denying the averments of the plaint. She also claimed that what is this? Is executed endorsement in this regard and then
2,000 rupees must be paid because he was for payment of even the balance 2,000 was and endorsement was made, but she did not put the signature to the endorsement.
based on these rival contentions, the trial court framed the following issues. The plaintiff was examined as PW1 and he marked documents as Exhibit P1 to P9. Full stop. The case was set down for cross-examination of PW1 on
Each 12 plaintiff was examined. 12/1.
12/7/2007.
And the next 92 days.
And thereafter the case was listed on 9th
9/2/2007.
9/2/2007. Since the
treated as absent.
there was no representation for the defendant, the cross-examination of PW1 was taken as nil, and the case was thereafter listed for the evidence of defendant number one on
24/2/2007.
Full stop. On the said date too, the defendant number one was absent, and therefore the case was thereafter listed for arguments
On 2/3.
on 2/3/2007. And the counsel for the defendant number one filed a memo stating that the written statement itself could be considered as the written submissions of the defendant. So, based on the based on the oral evidence of the plaintiff and the documents exhibited, the trial court decreed the suit and directed the defendant to conclude the sale transaction by executing a conveyance. Full stop. Being agreed by the aforesaid judgment and decree, the defendant filed RA 73 of 2008 before the first appellate court. The first step, during the pendency of the appeal before the first appellate court, the defendant filed IA number
3 for additional
IA number 3 of 2000.
additional ground.
IA number 3 for to urge additional grounds. IA 4 for
IA number 3, madam. IA number 3, order 41 rule 27.
IA number 3 and order 41 rule 27 of CPC.
IA 4 under order 41 rule 2 for raising additional.
IA 4 and order 41 rule 2 to raise additional grounds of appeal.
And IA number 5 and 6 under order 41 rule.
And IA 5 and 6 and order 41 rule 27 of CPC. Full stop. The defendant sought to place on record the medical documents of her husband along with IA number
3.
IA number 3 of 3. And what about 5 and 6?
5 and 6 suit.
And the fact that there were 3 other suits pending for specific performance in respect of the very same property. 3 suits that were pending in respect of the very same property before various courts. Full stop. The first appellate court secured the records of the trial court, heard the counsel for the parties and framed the following points for consideration. The first appellate court did not consider it appropriate to entertain the applications filed by the defendant numbered as IA number 3, 5 and 6 under order 41 rule 27, and also did not permit additional grounds to be raised in the appeal. Full stop. However, based on the oral and documentary evidence of the plaintiff which was on record, first appellate court dismissed the appeal and confirmed the judgment and decree of the trial court. Next, being agreed with the aforesaid judgment and decree, the present appeal is filed. Next, the learned counsel for the appellant submitted that the trial court submitted that the husband of the defendant was assaulted grievously, and the defendant was taking care of him, and therefore she could not take effective steps to defend the suit filed before the trial court. In this regard, the learned counsel submitted that the medical documents established that the husband of the defendant had suffered an amputation due to the assault, and though the first appellate court noticed the same, it held that the husband of the defendant was not dead, and therefore the defendant could still effectively prosecute the suit. Full stop. The learned counsel submitted that even for the examination in chief of the defendant, the trial court did not give enough opportunity. Full stop. This is countered by the learned counsel for the plaintiff, who submitted that the defendant was punctual before the court and that she received the cost imposed by the trial court since the plaintiff did not lead evidence on a particular day. Full stop. He contended that the trial court had granted opportunity to cross-examine PW1 and also to lead evidence which the defendant did not utilize, and therefore the trial court and the first appellate court were justified in decreeing the suit based on the available material. Next para. The process of any judicial intervention, the overarching process of any judicial intervention is to ascertain the truth and to provide substantial justice to the parties before the court. Full stop. Therefore, the court is not bound by rules of procedure or technical defects to deny or deprive the rights of the parties. Full stop. In the case on hand, the trial court and the trial court was justified in proceeding ahead to decide the suit, since the defendant did not participate in the suit. However, when the defendant pleaded her predicament before the first appellate court, the first appellate court was bound to act with alacrity, and it must have undone the loss of opportunity to the defendant, and must have granted and must have remitted the case for reconsideration. Full stop. This has indeed resulted in affecting the civil rights of the defendant in the suit real property. Full stop. The defendant is virtually condemned unheard. Full stop. Therefore, without commenting on the way in which the first appeal was disposed of by the first appellate court, this court considers it appropriate to set aside the judgment and decree passed by the trial court and the first appellate court, and considers it appropriate to remit the case back to the trial court for decision afresh. However, since the suit is filed in the year 2005, it is appropriate that the defendant is put on terms so that the defendant does not misuse the liberty granted to conduct the proceedings afresh. So in that way of the matter, this appeal is allowed. The impugned judgment and decree passed by the trial court and the first appellate court are set aside. The case is remitted back to the trial court for reconsideration afresh, after providing equal and sufficient opportunity to both the parties to adduce their evidence, both oral and documentary. The trial court is directed to permit the defendant to cross-examine PW1, permit the plaintiff to produce any additional documentary or oral evidence, and the trial court is directed to permit the defendant to cross-examine PW1 and or other witness within a period of 1 month from the date of the first appearance of the defendant and the plaintiff before the trial court. After conclusion of the cross-examination, the trial court is requested to dispose of the suit. Trial court is directed to permit the defendant to adduce evidence within a period of 3 months therefrom, and thereafter the trial court is requested to dispose of the suit within a period of 6 months. 3, 4, 10, 6 months. Full stop. Just to cost and put it. Even from 2005 till 2022, 17 years, 3 lawyers. Yes, sir. Yes. ಈ ಕಡೆ ಬಂದಾಗ 2000 ಹೇಳೋದು ನೀವು. ಕರೆಕ್ಟ್. ನೀವು ಈ ಕಡೆ ನಿಂತ್ರೆ 2000 ರೂಪಾಯಿ ಮೇಲೆ ನೀವು ಏರೋದೇ ಇಲ್ಲ ನೀವು. Even if we fill you up with vacuum, you don't rise. Helium gas hakkadu. It shall, however, be subject to payment of cost of some rupees 10,000 payable by the defendant to the plaintiff on the next date of hearing before the trial court. Parties are directed to appear before the trial court on first June 2022. Yes. Yes. Yes, please file for. No, but how can this happen, madam? This is a residential house. No, but why is the declaration refused? Yeah, brothers are. Huh?
So, yes, constructed the house and they demand register also because their names were counted out. But the time was never the relief sought in the pain was only respect of one of the persons without granted that were not.
But what is the source of your title?
I think you are demand register tax receipts and also
So how do you become the owner, man? How did you get? How did you get? How did you get it?
Under the partition.
Where is the partition? Exhibit? No, a partition Indian one. Please read that. And how is the defendant related to you? Go the partition leave property benefit source. Yes, is this property fall into the share of the plaintiff in the partition? Yes.
Totally out of 7, it was divided. 3.5 sides to the father of the defendant and 3.5 sides to the father of the plaintiff. Like now, under this partition, we are between the absolute rules. We have endorsed the question of the property in the house contract. That is why you know, so far as only injunction is granted in favor of the plaintiff. So far as declaration, the two have been discussed because no document of title has been explained. On this issue, this citing that Procedural has discussed.
No, but the suit is filed on behalf of so many people. Lindiya Gowda, Jayamma.
Originally, they are grandfather, there was a partition in the year 1965.
That is as per exhibit P13.
That is as per exhibit P1. It is in 1965 to be produced.
What is exhibit P13 then?
P13 is their family members. His father of his plaintiff is one sheet Kunle Gowda. And father of defendant is Kunle Gowda. 1965 is the partition between these two brothers. The subsequent partition under which they are claiming is between the sons, their own family members, mother and brother. That is why now if the lordship penny takes para 16 minutes, penny has been given a very separate group. Also, but so far as they have admitted the earlier partition, they were 1965. Lordship penny comes to para 16 minutes at page 16. PWI during the course of his cross-examination at PhD dated 9/11/2005 has admitted that partition was effected between his father and between the brothers of his father in the joint family property through registered partition deed dated 18/4/1955. PWI has also admitted the case of the defendant that the two properties totally measuring 7 cents of land, but PWI has denied the case of defendant that 3.5 cents of land and 7 cents of land towards eastern side was given to the share of the father of the defendant and western half portion measuring 3.5 cents was according to the share of his father. PWI has stated in his cross-examination that he does not know whether the property was totally measuring 36 people east to west and 105 people from north to south. Furthermore, the defendant has produced the original registered partition deed dated 18/4/1969, respecting of registered partition deed dated 18/4/1969, clearly admitted by PWI in his cross-examination. Further, PWI in his cross-examination has also admitted that the two properties is totally measuring 7 cents, and it was earlier belonging to his grandfather. This is an admitted fact that two properties are ancestral property of the plaintiff and defendant, and it is also an admitted fact that the said property was partition. Since the partition deed dated 18/4/1965 admitted by the plaintiff, I am of the opinion that the said document can be looked into in order to know the nature of the partition effected between the parties. The original registered partition deed dated 18/4/1965 is produced by the defendant at exhibit B. According to the defendant, there is mention in A and B schedule of the said registered partition deed regarding allotment of share in the scheduled property. Since exhibit B1 partition deed dated 18/4/1966 is an admitted document, I am of the opinion that there will be no bar to receive the decision of the said document. Each schedule A of the said partition deed property which was given to the share of father of deceased plaintiff, Kunle Gowda, son of Kunle Gowda, is mentioned. Further, in schedule B, the property which was allotted to share of defendant's father, namely Kunle Gowda, is mentioned. The certified copy of this said document is produced as exhibit B1A. PWI during the course of the examination in chief has reported that since one page of exhibit B1 was shown, he has produced the certified copy of the same as exhibit B1A. Exhibit B1A, their name is mentioned about giving of 3.5 cents of land to deceased plaintiff's father, Kunle Gowda, in schedule A, and giving of 3.5 cents of land to defendant's father, Kunle Gowda, in schedule B of 7 cents of land in survey number 280, situated at Arnold village. Therefore, the 3.5 cents belongs to the defendant's father, and thereafter it is applied. Now they are claiming to share even third of their unseen. That is why so far as declarative unit has been denied.
Where have you proved? Now the title of both the plaintiffs and the defendants in respect of 3.5 guntas is not in dispute. Question is whether the construction that is put up by the plaintiff lies within the 3.5 guntas. How have we established that it lies beyond?
So far as we regard to encroachment, we have admitted.
Where have you admitted? Where?
Para 26.
26.
The original plaintiff, apart from seeking relief of declaration, has also sought a relief of permanent injunction from the defendant. The changes in the two-sided property, the extent of 18.5 feet of north. It is also admitted about fencing of the main southern side of the two-sided property. Even in its cross examination, has also admitted possession of the native two-sided property. He has also admitted about issuance of legal notice.
Yes.
Now, there are separate suits for possession and what happened was we also filed application seeking for counter payment amendment. That application ID number 3 need to be distributed.
With the trial court.
When it was captured. Back to that page, Tara 28. The trial court has dismissed the application on the ground that there is a separate power tax. And now suit is already being filed under the year 2016. The OS number 210 of 2016. Seeking for possession.
What steps you have taken to show that this is the enclosed post? What are the steps that you have taken to demonstrate that the property that the plaintiff has constructed is encroached by him? Before the court, madam, what steps you have taken? Was a commissioner appointed? Then.
What has happened? We have not. These more documents of title have been placed in the they are ready for declaration.
They have antecedent title. They have please come to section 110. Evidence.
Only for 3.5. Beyond that, we cannot.
Please have a look at section 110. 110.
When the question is whether any person is owner of anything of which he should to be provision, the burden of proving that he is not owner is on the person who affirms that he is not owner.
So therefore, what is that you have done to establish that the area which is in his possession or his or their possession lies outside the 3.5? What is that you have done?
First thing, we have produced the original.
Right, that's been a question of your purpose. Whether in view of section 110 of the Evidence Act, the defendant had produced any material to establish that the plaintiff had encroached into the portion belonging to the defendant. Full stop. Next, in the absence of any such evidence, was the first appellate court justified in reversing the judgment and declare the trial court granting reversing the judgment of the trial court, granting the relief of declaration of title of the plaintiff to the social property. Huh? Yes. Paper books to be filed within 8 weeks. Parties are directed to maintain status in respect of the suit property. Yes, next. Appeal is filed by the suit is dismissed. Suit is dismissed. Suit is filed for declaration. Yes, please.
Property. Originally purchased by Rangappa, son of Rangappa, who is dated 23/3/19.
Kappa in favor of Siddha Lingappa.
Rangappa, Kamalappa as compared to Rangappa.
Yavaga?
23/3/19. Property is available on 134 Rangappa. The property has been litigated. The amount number 36 for 1957. 2 years 13 guntras and 7 and 25 guntras and 7 130. There are several transactions were made by system Lapa, who is to the data and the services. But subsequently, after the year 2008, the plaintiff number 4 has raised this on dispute regarding revenue.
Respondent number 4 under which defendant?
Raised the several disputes regarding revenue. And that was remanded to Procedural in the year 2008 and 9. From the year 1986 to well, in the year 2015, we are not evaluating this and even after dispute of
How is the plaintiff related to Rangappa?
property was pronounced by the Ranga and they are the successors of Ranga. So they are not
Rangappa sold it to Sitamalappa and Ranga is also the same.
it's a different person.
They are the same persons.
They are a different person. But our contention is firstly, they have not showed that they have not produced any document to show that by the successors of Ranga means only one theological tree issued by the is not. They have not examined any difference in methods, and they have not examined the other. PWQ is examined in your scope of the Like our revenue entries, several transactions for land between the Sitamalappa has declared the property to his father. Subsequently, it was cancelled. These dependents are sold, dependent 125 are sold the property to dependent number 6. Subsequently, it has been cancelled.
Rangappa yarinda ಕೊಂಡ್ಕೊಂಡಿದ್ದು?
Rangappa is the ancestor property of Ranga.
But what is the significance of this statement? Said Ranga, not Rangappa, son of Rangappa, and plaintiff ever sold. Already sentence full clearly. Mister, what is the significance of this plaint government? They said Ranga, son of Siddha, nor Rangappa, son of Rangappa, and plaintiff ever sold the suit property to anybody, including Rangappa, son of Dodda Rangappa, in any manner. What is the significance?
Yes, they made a pleadings. They made that including Rangappa is not shown there. Means Rangappa. So Siddha bin Ranga is our opposite.
Ranga bin Siddha.
The court has come to conclusion that they have not produced any document to show that they are the owner of the property and they are successors of Ranga. So first of all, the court relied on only oral extract. In oral extract, an entry is made showing that there was an entry of Ranga with Siddha. And the very same oral extract shows that this Rangappa has sold the property. Rangappa has sold the property to Sitamalappa. That entry has not been considered. That exhibit 3 needs to be reappreciated.
ಆಯ್ತು ಓದಿ ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ ಫಸ್ಟ್ ಪ್ಲೇಟ್ ಕೊಟ್ಟು
Number 14. The plaintiffs are going to sue for case of resurrection of
ಇಷ್ಟಿಂದ ಓದ್ತಾ ಇದ್ದೀರಾ? ಓದಿ.
According to the plaintiff, on the Ranga son of Siddha was raised as a plaintiff and known by it also asserted in the case of Rangappa and Siddha. And neither Rangappa and his children did not permit or confirm this. Plaintiff said that they will be the property. On the contrary, different observe that 7 another one. And that's one of our. And purchase the same proof. The research.
Para 18 the other. Para 18 the other. It's already you. I read that. Please read for para 18.
Apart from that, the name of the defendant is on Bangappa. Now, but the document which shows that you are but on what basis he should see that and usually because it would be the purchaser does not occur any interest, does not have any interest.
Secure the records. Office director to secure the records. Yes, 44. Yes, Subramanya. Yeah. Huh? Huh? Yes, Purboda. Yes, what is this?
E-17 mainly based on the said to have been executed by number 6. The agreement number 7 also claims that the bill has been executed by first defendant.
How are the plaintiffs and defendants related?
They are the children of two brothers, originally Narasimha and Narasimha, owners of these two properties.
Narasimhaya and
Narasimha.
Narasimhaya na Narasa Hanumaya na?
Narasimha, sorry. Narasimha.
Who are the plaintiffs? Wives of Narsaya. Yes.
Maybe the type of business the suit on the ground that the suit was filed by vintage. And the second thing is, in view of section 6 amended by examining government, the alienation made prior to 2012-2004, the order to not time.
Please give me the, sir, who is the defendant number 2, defendant number 3? What about defendant number 3? 4, 5, 6 LR. They're all purchasers. Defendant number 2, Javak sale aitu.
The same thing is 21/4/1990.
21. PC Chikka Chennai Javak sale aitu. Chikka Chennai. Muhammad Ibrahim alias Parajan under registered sale date 7678. Parajan is 7678. Said Abdul Latif sold the above properties under the registered sale date dated 4/10/95. Defendant number 1 so. So 1 to 4/10/95 and 21/4/99. What about Chikka Chennai? E4 is placed ex parte. Land tribunal was granted 1 acre of land is in his favor. So you're not ready. Yes. After vacation.
Participants, raise your hand.
At the request of the council for appearance, Mr. After vacation. ಯಾರು ನೀವ್ಯಾರು? ಹಾ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಅಲ್ರಿ? ಹೆಂಗ್ ಗೊತ್ತು ನಿಮ್ಗೆ? ಇಷ್ಟ ಆಗೋಯ್ತಾ? ಮತ್ತೆ ಹೇಳಿ ಹೆಂಗಿದೆ? Notice call for eclipse.
46. Badrinath.
Super partition. The current court decrees. Current report, they are the children of Mahadeva, who is the first different and respondents to all that. The Bangal Nayaka and the Bangal Nayaka was first grade, second grade, everybody is super. Respect of suitability because suitability goes on. So item number 5, it's the first different thing.
Why was the suit dismissed?
This is because they are already partition.
Please read that portion.
Page number. Analysis of page number 104, 50, 104. First one is file number 15. First one is plaintiff's the name of the plaintiff's item number 3 of 6. The second is during the lifetime of all of the churches, all of which exhibit equal and to the extent of 0.42 plus or 1 side 2002, subsequent and 60 or prior to the item number 3 of this report is as per exhibit
You will get the records. Office is directed to secure the records and put the drawing of a final decree proceedings. Instead, however, the final decree proceedings can continue. Really?
Number 2. This is filed by 19 for declaration of title and for permanent investment. And for a declaration that the sale deed in my favor executed by first defendant is null and void, fabricated. And not also for the injunction not restraining, not taking compensation.
What is the date of the CPA? What is the date of the sale deed? Sorry.
Sale deed 2007. So the name of the first defendant showed till 2007. According to the plaintiff's lord, it is plaintiff's father who was granted the land. And he died in 1971. My lord, there was no mutation. Name of Narayana continued, who is first defendant in my case, and the first defendant conveyed the land.
And they too not pursuing the CG, my name was changed. I entered, and RTC's can be entered in my name. Then when land was acquired, compensation can be awarded in my favor. But thereafter will not be collected by the suit for declaration that he will not. But he has deleted a declaration prayer. Only if you are to challenge not in the respect of CG not that. But in fact, one other matter, similar matter not had come up using the party. The last occasion and current, this also have come up. But there was office objection and it was overruled not that. Posted for where. That case is not. They were rejected, but same ground to same course to same reasoning.
Is it the same parties?
Different parties. Same grounds. Same grounds.
Same grounds, but how is that relevant?
Yes.
So this the plaintiff's father and the defendant. Plaintiff's father Narayana HR and the defendant Narayana HR are two different persons.
Two different persons.
Right.
Two different.
How have we established that Narayana HR is the grant?
Narayana HR was the owner, that is first defendant. But he was the owner because his name was shown in the RTC not up to 2006. But according to them, the name of father died in 1971. But the exhibit P-23 is the grant certificate in favor of Narayana HR. Now, question is who is the Narayana HR?
Improve Narayana HR, son of him.
But he says, plaintiff says not, it is his father.
It is the father's name of Narayana HR.
That is seen upon Milord. According to the state Milord, it is seen upon.
Grant alien.
Grant alien, grant alien, the lordship may really there are two certificates Milord.
Grant alien is
Narayana Achar, yes, Narayana Achar.
Son of Manachar, Milord.
Son of?
Manachar. That is my grandfather.
Manachar. But in the grant certificate copy of time, there is no such in P3. There is no such name as father, Manachar. But that was produced by the compensation is in deposit Milord.
What compensation?
Milord, 1971, Milord, my father has expired. 2007, Milord, they have fabricated, Milord, the sale deed. Both
where is it in deposit? Where is the amount in deposit?
In deposit before LSC court.
It is in LSC 5 of 2017.
1971, Milord, he has expired. 2007, Milord, they have collected.
For which court?
And before the civil judge, Milord, Shumaga.
Civil judge and JMFC or?
JMFC, Shumaga. In LSC 5 of 2017.
There is no case at all, Milord. Both courts concurrently have held, Milord, in my favor that they have fabricated.
Let us be satisfied. Now he says that in one proceeding your father's name is shown, but in the grant certificate your father's name is not shown.
No, it is clearly discussed, Milord. Exhibit P13, Milord, is the application filed by my grandfather.
We'll get the records. We're not admitting
date may be fixed, Milord. At least the date may be fixed.
In the meanwhile, the compensation amount deposited in LSC 5 of 2017 before the civil judge and JMFC Shumaga shall not be released. Just after vacation. Yes, next.
The date may be given, Milord.
We can't fix a date for the coming of the after vacation.
Appearing for appellant.
JD.
Appearing for appellant, Milord. Here, Milord, the suit. It's a defendant's appeal, Milord. Defendant appeal, Milord. Suit for declaration, recovery of possession and injunction, Milord, in respect of 36 guntas, Milord, which is suit filed by the respondent, Milord. The suit is, Milord, in respect of survey number 24/2, saying that, Milord, the defendant has encroached 36 guntas of land in survey number 24/2 of Udugni Hobli Uttrani village, Milord. That is the case before the trial court, Milord. The case of the plaintiff, Milord, he purchased the property, Milord, on 4/3/2010, and when he conducted survey, Milord, on 15/7/2011, in a survey, it is found that 36 guntas have been encroached by the defendant Thereby, my lord, he files a suit, my lord, recovery of possession and consequential injunction. Before the trial court, my lord, it is the defense taken by the defendant that, my lord, they are in possession from more than 100 years, my lord. As such, my lord, this particular portion of land, 36 guntas, my lord, was in custody possession from their father and grandfather's time, my lord.
Improve madidra.
There, my lord, some of the documents, and they have produced few documents, my lord, not establishing the entire possession, my lord. To an extent, my lord, the statements, my lord, and the survey officer who adduced evidence, my lord, he only stated that there is an arecanut trees in the possession, arecanut trees, my lord, in this particular land. And moreover,
arecanut trees anybody can plant, Mr.
But, my lord, it is not the case, my lord. This particular land of the plaintiff, my lord, has grown with an arecanut trees, my lord. That is not his case, my lord.
Is that the way you prove your possession?
No, except that, my lord, my actual submission is, my lord, his case of possession in respect of 36 guntas, only when he found that, my lord, the survey officer has made a report that there is an encroachment. My actual submission, my lord, at the time of purchase and executing the sale deed, this particular possession of 36 guntas not handed over to the plaintiff, my lord, by the earlier vendor.
But what do you say? Do you say that you're in unauthorized possession?
No, my lord, I have taken a contentional adverse possession, my lord, since 100 years.
Therefore, you admit the title of the plaintiff.
They are admitting the plaintiff, not plaintiff, my lord, plaintiff's vendor, and later on plaintiff, my lord.
Therefore, plaintiff's title is accepted.
Yes.
How do you say when did you? How do you prove when you came into possession? When it became adverse?
Vendors at the time, during the time of vendors, my lord, vendors' father's time, my lord.
Yes.
Kindly, my lord, the findings of the trial court itself, my lord, where some of the defense, my lord, is extracted at page 20 of the trial court judgment, my lord.
Yes.
That, my lord, defense is stated, my lord, at page 22. Page 21, my lord, is the defense stated, my lord. Page para 5. May I read, my lord?
Page 21 of the first appellate court judgment.
No, my trial court.
Trial court page 20 ilva.
Sorry, my lord. I'm sorry.
The 21 is the judgment portion.
Yes, my lord.
Which paragraph in the judgment of the trial court you want to read?
Of the trial court, my lord. Para 5 of the trial court judgment. Para 5 of the judgment.
Yes, please.
ನ್ಯಾಯಾಲಯದಿಂದ ಪ್ರತಿವಾದಿ ಸಮನ್ಸ್ ಜಾರಿಯಾದ ಮೇಲೆ ಪ್ರತಿವಾದಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಾಗಿ ಪ್ರತಿವಾದ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿದ್ದು ತನ್ನ ಪ್ರತಿವಾದ ಪತ್ರದಲ್ಲಿ ವಾದಿಯು ತನ್ನ ಪ್ರತಿವಾದದಲ್ಲಿ ಹೇಳಿದ ಸಂಗತಿಗಳನ್ನು ಅಲ್ಲಗಳೆಯುತ್ತಾನೆ. ಮುಂದುವರೆದು ಶಿಕಾರಿಪುರ ತಾಲೂಕು ಉಡುಗಣಿ ಹೋಬಳಿ ಉತ್ತರಾಣಿ ಸೋಣಸು 24/2 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 9 ಗುಂಟೆ ಇದ್ದು ಸದರಿ ಸ್ವತ್ತು ಮೂಲತಃ ಪ್ರತಿವಾದಿಯ ಅಜ್ಜನಾದ ಕತಲ್ ಬೇಗ್ ಅವರ ಸ್ವಾಧೀನದಲ್ಲಿ ಇತ್ತು. ತದನಂತರ ಕತಲ್ ಬೇಗ್ ಮತ್ತು ಅವನ ಮಕ್ಕಳ ನಡುವೆ ಕುಟುಂಬದ ಸ್ವತ್ತುಗಳು ವಿಭಾಗವಾದ ಕಾಲಕ್ಕೆ ದಾವಾ ಬಿ ಸ್ವತ್ತು ಪ್ರತಿವಾದಿಯ ತಂದೆಯ ಸಹೋದರನಾದ ಖಾದರ್ ಬೇಗ್ ಅವರ ಹಿಸ್ಸೆಗೆ ಬಂದಿದ್ದು ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಖಾದರ್ ಬೇಗ್ ಅವರು ತಮ್ಮ ಜೀವಿತ ಕಾಲದಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದರು. ಸದರಿ ಬೇಗ್ ನಿಗೆ ಯಾವುದೇ ಸಂತಾನ ಇರಲಿಲ್ಲ. ಆದ್ದರಿಂದ ಪ್ರತಿವಾದಿಯ ತಂದೆ ಮತ್ತು ಮೇಲಿನ ಖಾದರ್ ಬೇಗ್ ರವರು ತಮ್ಮ ಪೂರ್ವಜರ ಕಾಲದಿಂದಲೂ ಯಾವುದೇ ಅಡ್ಡಿ ಆತಂಕಗಳಿಲ್ಲದೆ ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದರು. ಮುಂದುವರೆದು ಸದರಿ ಖಾದರ್ ಬೇಗ್ ನಿನಗೆ ಯಾವುದೇ ಸಂತಾನವಿರದೆ ಇದ್ದುದರಿಂದ ಹಿರೇಜಂಬೂರ್ ಗ್ರಾಮದ ರಾಜಶೇಖರಯ್ಯ ಬಿನ್ ಪುಟ್ಟಪ್ಪ ವಾಜಿಯಲ್ಲಿ ರವರು ಕೆಲವು ಕೊಟ್ಟಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡು ದಾವಾ ಸ್ವತ್ತಿನ ಕಂದಾಯ ದಾಖಲೆಯನ್ನು ತನ್ನ ಹೆಸರಿಗೆ ಬದಲಾವಣೆ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. ಆದರೆ ಯಾವತ್ತೂ ಸಹ ದಾವಾ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನವನ್ನು ಸದರಿ ರಾಜಶೇಖರಯ್ಯನವರು ಪ್ರತಿವಾದಿಯಿಂದ ಪಡೆದುಕೊಳ್ಳುವ ಪ್ರಯತ್ನವನ್ನು ಮಾಡಿರುವುದಿಲ್ಲ. ತದನಂತರ 26/2/1975 ಸುಬ್ರಾಯ ಗೌಂಡರ್ ಅವರಿಗೆ ರಾಜಶೇಖರಯ್ಯನು ದಾವಾ ಸ್ವತ್ತನ್ನು ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿಯವರು ಸಹ ಯಾವತ್ತೂ ದಾವಾ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನವನ್ನು ಪ್ರತಿವಾದಿಯಿಂದ ಪಡೆದುಕೊಳ್ಳುವ ಪ್ರಯತ್ನವನ್ನು ಮಾಡಿರುವುದಿಲ್ಲ. ತದನಂತರ ಸದರಿ ಸುಬ್ರಾಯ ಗೌಂಡರ್ ಅವರು ಮೃತಪಟ್ಟಿದ್ದು ಅವನ ಮಗನಾದ ಎಸ್ ಕಣ್ಣಪ್ಪನು 2010ನೇ ಸಾಲಿನಲ್ಲಿ ವಾದಿಗೆ ದಾವಾ ಸ್ವತ್ತನ್ನು ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ವಾದಿಯವರು ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುವ ಬಗ್ಗೆ ರಾಜಶೇಖರಯ್ಯ ಸುಬ್ರಾಯ ಗೌಂಡರ್ ಅವರಿಗೆ ತಿಳಿದಿದ್ದು ಯಾವತ್ತೂ ಸಹ ಪ್ರತಿವಾದಿಯನ್ನು ದಾವಾ ಸ್ವತ್ತಿನಿಂದ ಹೊರಹಾಕುವ ಪ್ರಯತ್ನ ಮಾಡಿರುವುದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ದ ಡಿಫೆನ್ಸ್ ಮೈ ಲಾರ್ಡ್ ಟೇಕನ್ ಬಿಫೋರ್.
ಇದನ್ನ ಹೆಂಗ್ ಪ್ರೂವ್ ಮಾಡಿದಿರ?
But to prove this, my lord, he has only produced few documents, my lord. Not
correctly. Subraya Gounder na ಕರೆಸಿದಿರಾ, ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸಿದಿರಾ?
That Subraya Gounder is no more, my lord, as per my instructions, my lord.
Anybody who has seen you cultivating for at least 12 years.
Yes, my lord. That is
Adhe
one fact, my
evidence
lord.
ಮಾಡಿಸ್ತೀರಾ?
My actual submission is, my lord, only two things, my lord. The plaintiff has claimed the possession, my lord, only from 2011. Admittedly, my lord, as on the date of executing the sale deed, whether he acquires the possession, my lord, in respect of this 36 kuntas, my lord.
Yes. At least ಆಯ್ತು ಅರೆಕನಟ್ಟಿ ಎಷ್ಟು ವರ್ಷದ ಟ್ರೀ ಅಂತ
15 ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲಿ 15 ವರ್ಷದಿದೆ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. Para 21, so para 21 of the trial court judgment. CW, the court commissioner was appointed. So survey officer was adduced this evidence. ತಮ್ಮ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ವಾದಿಯು ತನ್ನ ಸೊತ್ತನ್ನು ಅಳತೆ ಮಾಡುವಂತೆ ಸಲ್ಲಿಸಿದ್ದ ಅರ್ಜಿಯ ಮೇರೆಗೆ ಸರ್ವೆ ನಂಬರ್ 24/2 ಸೊತ್ತನ್ನು 15/7/2011 ಅಳತೆ ಮಾಡಿ ಕಲ್ಲು ಕಂಬ ನೆಟ್ಟಿದ್ದು, ಈ ಸಂಬಂಧ ನಿಶಾನೆ P5 ರಿಂದ 7 ದಾಖಲೆಯನ್ನು ನೀಡಿರುವುದಾಗಿ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ಅಳತೆ ಕಾಲಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 23 ಹಿಡುವಳಿದಾರರು ಸರ್ವೆ ನಂಬರ್ 24/2 ದಕ್ಷಿಣಕ್ಕೆ 36 ಗುಂಟೆ ಸೊತ್ತನ್ನು ಒತ್ತುವರಿ ಮಾಡಿರುವುದಕ್ಕೆ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿಯವರನ್ನು ಪ್ರತಿವಾದಿ ಪರ ವಕೀಲರು ಪಾರ್ಟಿ ಸಾಲ್ವ್ ಮಾಡಿದಾಗ ಸದರಿ 36 ಗುಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ ಪ್ರತಿವಾದಿಯು ಅಡಕೆ ತೋಟ ಮಾಡಿದ್ದು, ಸದರಿ ಮರಗಳು 15 ರಿಂದ 16 ವರ್ಷದ ಮರಗಳು ಎಂದು ಒಪ್ಪಿಕೊಳ್ಳುತ್ತಾರೆ.
12 ವರ್ಷದೊಳಗೆ ಇದೆಯಲ್ಲ. Suit is filed within 12 years then.
But my lord, earlier to that, my land was in possession.
Correct, mister. But what is there to show that? What is the evidence to show that even before you planted these areca trees, you were in possession? What is there to show that?
There is no material produced, my lord. My actual submission, my lord, as on the date of sale, my lord, this particular 30 kuntas of possession is concerned, it is not handed over to the subsequent purchaser, that is plaintiff. Here, my lord, the documentary title was transferred in the absence of possession.
Anyway, you admit the title, but you say that you are in possession. Possession you are not able to establish.
But my lord, admittedly, the plaintiff possession in respect of 36 kuntas, it is not the case that, my lord, after his purchase, I have encroached the property. Only after purchase, he found that it has been encroached earlier.
Yes. So earlier is when?
That is, my lord, my contention, my lord. I was not encroached. I was in possession, my lord, since 100 years.
All right. Appeal is dismissed. Yes, next. Yes, please.
The appellate
Sir, please be loud and clear, sir. I can't understand. I can't hear you.
Therefore, it was the court event was also taken. It was very and the board was and the second thing, each year and community body is not sure. The only requirement of the land of the and of course, the appellant total was good and thickness, and we were not able to accept that. The board issue after all the members, permanent members, we are not, and even the after the commission of the meeting.
ಆಯ್ತಲ್ಲ ಆಗೋದು ಮೀಟಿಂಗ್ ಆಯ್ತು ಎಲ್ಲ ಆಯ್ತು ಆಪರೇಷನ್ ಸಕ್ಸಸ್ಫುಲ್ ಪೇಷಂಟ್ ಇಟ್ ಎಲ್ಲ ಆಗೋಯ್ತಲ್ಲ ನೋಟಿಸ್ ಆಯ್ತು ಜನರಲ್ ಬಾಡಿ ಆಗೋಯ್ತು ಯು ಸ್ಟಿಲ್ ಕೀಪಿಂಗ್ ದಿ ಲಿಟಿಗೇಷನ್ ಅಲೈವ್ Correct. So that stage is already over. Term mugdogide. Term of that body is already over, sir. Huh?
They are trying to application. Directing third respond. To convene the fresh meeting because
No, that body is already, its term is already over, sir. Term mugdadmele ಏನು ಮಾಡ್ತೀರಾ? The term is already over.
the other aspect is the respondents are to name are not a member of the society. That are to declare.
Keep it pending, please. Term is over. You no. General body meeting, that minutes you want it to be set aside. Right? Issue notice.
Society, working society. The first respondent has collected, the second respondent has collected proof for declaration of money in the first respondent before the sale court. Sale court, so we indicate the daily basis. 7/9/2000 is declared unlawful. This is a massive discovery. The appellate was declared to the respondent. And at the time, in the year 1986, the society has purchased the 2 acres purchased number 30 from the 2 persons, 2 farm sites. So accordingly, they have found layout and distribute site. The first respondent has purchased the one site.
But who are you? You are the secretary. Ex-secretary or
Ex-secretary.
So what is your role?
I actually have no role in this case. The was appointed.
But how are you filing an appeal?
Because the respondent is appealing to pay the amount.
I will not be paid out of your pocket. You paid from the society.
But the sale court
Some amount will have to be paid from the society, sir. Not from the by the secretary, from out of his pocket. Defendant, please listen to me. Defendant number 1 is directed to pay. Defendant number 1. Defendant number 1 is KM Leelavati. Correct. Defendant number 1 is directed to pay a sum of rupees 3,05,635 along with interest at the rate of 6%. Are you the defendant number 1? You are defendant number 1. Please wait, sir. Please wait. Please wait. Appeal is filed by you. Who filed the appeal? Defendant number 1 filed the appeal. Correct? What happened?
Arunti has purchased the property from Leelavati. The dispute between the first and second respondent, not consulting the fourth respondent. Fourth defendant.
Respondent and the defendant. That is why I keep telling all lawyers, I don't know why people don't understand. No, Mr. You say appellant, then you jump and say defendant.
And secretary, society. Second defendant to go to the Leelavati has purchased the right from the society. Working society, in 1980.
Now the trial court has said the gift sale deed executed by defendants 2 to 4 in favor of defendant number 1 is null and void. Correct? Defendant number 1 says, please give back my money. How are you agree? Have you challenged the order of the trial court? Judgment and decree of the trial court. Then, sir, plaintiff filed a suit saying that the defendant number 1 to 4, 2 to 4 have illegally executed a sale deed in favor of defendant number 1. Correct? Trial court said, yes, it is illegally executed, and therefore it directed the defendant number 1 to pay the money to the plaintiff. Appeal was filed by the defendant number 1. In the appeal, the trial court, first appellate court said that the money has to be paid to the plaintiff by the defendants 1 to 2 to 4 severally, jointly and severally. Did you challenge the judgment and decree of the trial court annulling the sale deed in favor of defendant number 1? Then how can you file a second appeal? ಅದಾದ್ಮೇಲೆ ಬ್ಯಾಂಡೇಜ್ ಆಗಕ್ ಮುಂಚೆ ಇದು ನಾನು ಕೇಳ್ತಿರೋದು ಬ್ಯಾಂಡೇಜ್ ಆಗಕ್ ಮುಂಚೆ ಏನ್ ಮಾಡಿದೀರಾ ಅಂತ. Then how can you file a second appeal? So these are all consequences, sir. The sale deed in favor of defendant number 1 is held to be illegal. So therefore you are bound to repay the money if you have taken the money. So therefore how can it? Sir, again I am saying it, adella bandage ಆದ್ಮೇಲೆ ಅದು ಕಟ್ಟಾಗಿ ಸೂಚರ ಆದ್ಮೇಲೆ bandage ಆದ್ಮೇಲೆ ಹೇಳ್ತಿರೋದು execution ಬರೋದು. Why did you not file an appeal challenging the judgment and decree of the trial court, setting aside a sale deed in favor of defendant number 1? That finding remains so far as you are concerned. Then ನೀವು ಯಾರೇ ಫೈಲ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ನೀವ್ಯಾಕೆ ಫೈಲ್ ಮಾಡಿಲ್ಲ? ಬರ್ಕೊಳ್ಳಿ. This appeal is filed by the defendant number 4 in OS number 29 of 2014. The suit was filed, the suit in OS, the partition henceforth be referred to as they were arraigned before the trial court. Next, the suit in OS number 29 of 2014 was filed for declaration that the sale deed dated 8/1/1987 executed by the defendant number 2 to 4 in favor of defendant number 1 as fraudulent, illegal and void, and for a consequent declaration that the sale deed dated 7/9/2007 executed by the defendant number 1 in favor of the plaintiff in respect of the suit property was again fraudulent, illegal, void and non-est, and to recover a sum of rupees 6,05,160 from the defendants 1 to 4 jointly and severally. Stop. The said suit after contest was decreed in part, and the defendant number 1 was directed to pay a sum of rupees 3,05,635 along with interest at the rate of 6% per annum. Stop. Feeling aggrieved with the aforesaid judgment and decree, the defendant number 1 alone filed RA 40 of 2018. Full stop. The first appellate court held that confirmed the finding of the trial court that the sale deed in favor of executed by the defendants 2 to 4 in favor of the defendant number 1 was fraudulent, and therefore it directed the defendants 1 to 4 to pay the amount of rupees 3,05,635 along with interest to the plaintiff. Full stop. It is relevant to note that the defendants 2 to 4 did not challenge the judgment and decree of the trial court in OS number 29 of 2014, by which the sale deed executed by the defendants 2 to 4 in favor of the defendant number 1 was held to be fraudulent. Full stop. The defendant number 4 short circuiting the appeal remedy has now filed a second appeal challenging the judgment and decree of the first appellate court by which the defendant number 4 was directed to pay along with the defendants 2 and 3. Full stop. Since the finding of fact regarding, since the finding of fact by the trial court and the first appellate court, finding of fact recorded by the first trial court that the sale deed executed by the defendant number 1, defendant number 2 to 4 in favor of the defendant number 1 was fraudulent is not challenged by the defendants 2 to 4 in a regular appeal. Question of entertaining an appeal at the instance of the defendant number 4 would not arise. It is also found that the defendant number 4 was the ex-secretary of the defendant number 2, and therefore a defendant number 2 which is now under liquidation and is represented by the liquidator. In that way of the matter, the appeal at the instance of the defendant number 4 is not maintainable, and therefore this appeal is dismissed.
Kindly notes if I'm. What's next matter notes in final hearing?
Yes.
Can I be provided a day's accommodation notes tomorrow?
51.
Please, Manoj.
51 is gone beyond vacation. Oh, yeah. Huh? Please come at 2:30.
Court officer, madam. Court officer.
Sir, really, sir.
A serial number 16, sir. 16. Serial number 16, sir.
16,
how, sir?
Two weeks time ಕೊಟ್ಟಿದ್ದಾರೆ sir.
Okay, sir.
63, sir. 63.
Court officer? Court officer?
Court officer? Court officer? Court officer, court officer,
ಹಲೋ ಹಲೋ
serial number 37 ಏನಾಯ್ತು sir?
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಮೇಡಮ್.
Okay, sir.
Court officer.
ಹೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಏನಾಯ್ತು? ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
30
ಹೌದು 30 30.
30 ನೋಟಿಸ್ ಆಗಿದೆ ಸರ್.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಫೈನಲ್ ಏನ್ ತಗೊಂತಾರ?
ಹಾ ತಗೊಳ್ಳಿ ಸರ್.
ಇಲ್ಲ ಒಳ್ಳೆ ಆಪರ್ಚುನಿಟಿ ರೀಚ್ ಆಗಿದೆ ಮುಗಿಸ್ಕೊಳ್ಳೋದು ಬಿಟ್ಟು ಯಾರು ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ ನೋಡೋಣ. ಟೇಕ್ ಕೇರ್ ಆಫ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್, ಲಾ ವಿಲ್ ಟೇಕ್ ಕೇರ್ ಆಫ್ ಇಟ್. ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ ನೋಡೋಣ. ಆಯ್ತು, ಲೆಟ್ ಹಿಮ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ ನೋಡೋಣ. There's any difficulty with it? Hello sir, facts ಮೇಲೆ ಹೇಳಿ. If you have any difficulty with it. Sorry.
Correcting the amending the process, I noticed I told you, respondent told me also notice started.
ಸರ್ವಾಗಿದೆ ಅಂತಲ್ಲ, ಬಟ್ ಏನು ಆಗಿದಿಲ್ಲ. 12B and 12C ಇದೆ.
ಅವರು ಎಲ್ಲ ಅವ್ರ ನೋಟಿಸ್ ಆರ್ಡರ್ ಶೀಟ್ I went through the order.
12A is also dead. Is that proposed 12A or only 12A?
Proposed 12A ಎಲ್ಲ.
And who is this respondent number 12A? 12 ಇದ್ಕೊಂಡು ಪ್ರಪೋಸ್ 12 ಹೆಂಗಾಗುತ್ತೆ? Correct. So what is this IA 4 to 6 of 19 ಅದೇನದು? 4 to 6 of 19 is filed for bringing the legal representatives of R12. ಇದೇನಾಗಿದೆ?
ಅದು ಅಲ್ಲವ, ಅದು ಸರ್ವಾಗಿದೆ. 12A it was written saying that 12A passed. So I filed a separate AS ಎಲ್ಲ ಸಬ್ 12A. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಅದೊಂದು
ಬರ್ದು ಬಿಟ್ಟಿದ್ದಾರೆ, ಚೆಕ್ ಮಾಡ್ಬೇಕು.
ಬರುತ್ತೆ ಸೇಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
IA 123 of 2022 ನಲ್ಲಿ office objections raised on IA 123 of 2022 is overruled. Issue notice on IA 123 of 2022. ಅಷ್ಟೊಂದು ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡೋದು IA ಹಲವಾಗಿತ್ತು. ಅದು IA 123 of 2022 ಹಲವಾಗಿತ್ತು ಅಂತ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದೆ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಆನ್ IA 123 of 2022 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅವರು ಸರಿ. ಈ ನಾಲ ಎಷ್ಟು ಅಡಿ ಅಗಲ? ನಾಲ ರಸ್ತೆನಾ ಇದು? ನಾಲ ಅಂದ್ರೆ ಇಸ್ ನಾಲ ರೋಡ್ ಅವ ಕೆನಲ್ ರೋಡ್? ಅದೇ channel runs next to this nala. Perfect. The learned counsel for the applicant and the respondent have filed a sketch. I filed a memo enclosing a sketch of the properties that would fall to the share of the applicant and the respondent. In view of the since the parties have filed the sketch, the same shall form part and parcel of the compromise petition. So the second appeal stands disposed of in terms of the compromise petition. Office is directed to issue a decree, draw a decree in terms of the compromise petition, and the sketch filed today shall form part and parcel of the decree. Yeah. The parties are at liberty to get the revenue records changed to their names based on the compromise petition entered.
Number 5.
This RG Somsekraya. What is there? Advocate ಯಾರೋ ಬಂದಿಲ್ಲ ಯಾರು? This is Mahendra. There is no representation for the counsel for the respondent number 2A, G and I to L. So, this is appeal after vacation.
Pratik Casey. Serial number 8, Pratik Casey.
Password.
Number 17.
ಜೋರಾಗಿ ಮಾತಾಡಿಲ್ಲ ಮಾಸ್ ತೆಗಿರಿ. What is this, madam? Class title amendment ಮಾಡಿದ್ರಾ? Class title amendment ಮಾಡಿಲ್ವ ಇನ್ನ? ಪಾಸ್ ಔಟ್. ಮೇಡಮ್ ಬೆಳಿಗ್ಗೆನೇ ಹೇಳ್ದೆ ನಿಮ್ಗೆ. Whatever that has to be done, you please do it, madam. That is why I passed it over. Pass over. Yes.
Number 34. Ravindra Gowda.
Appeal is admitted. What is this IA 1 of 21?
Not to put up any construction, restraining the not to put up any construction or any usually election. Respondent number 1 and 2, plaintiff to the trial court. Appellant for the defendant number 2. Respondent number 3 was the defendant number 1. We filed a suit for partition against the defendant number 1 and 2, stating that the plaintiff and the defendant number 1 form an Hindu unrelated family and seek for partition. There are in total 9 scheduled properties. Really, the trial court will decree the suit and grant the plaintiff to the state. Appeal by the same, the defendant number 1 would go file appeal. The defendant number 2 will be file appeal. Defendant number 2, the purchaser of item number 9 scheduled properties. He claims to have purchased the same.
Is this a vacant site?
Yes, sir. Vacant.
Don't put up
A stock is there. We have right and A stock is there.
Cattle ಕಟ್ಕೊಳ್ಳಿ ಎಷ್ಟು ಹಾಕಿಟ್ಕೊಳ್ಳಿ.
Buildings we are not putting up any.
Don't put up any.
Even if now clean ಮಾಡಕ್ಕೆ that particular incident FIR will happen. And if they are cleaning the site in their own amendment, ನಾವು ಕ್ಲೀನ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅವರು ಅಬ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡೋದು ಅವರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ. ಈಗ ಪಾರ್ಟ್ ನಾವು
ಬರ್ಕೊಂಡು IA 1 of 21.
ಸ್ಟೇಟಸ್ ಕೊಡ್ತಾರೆ ನಾವು ಪ್ರಾಬ್ಲಮ್.
No maintenance status quo. I will present the application. IA 1 of 21. Filed for interim is filed by the respondent number 1 and 2, seeking for an order of interim injunction restraining the appellants from putting up any construction or changing the nature of the suit shell property. Stop. The suit shell property is admittedly a vacant site. It is the subject matter of this appeal. Stop this. The respondents 1 and 2 contend that after this court granted an order of stay, the appellant has attempted to put up construction. Stop. When the respondents obstructed the construction, the appellant and his henchman assaulted the respondents brutally in the somebody is killed brutally in the Sister, what do you mean by Sister Bharati brutally? What do you mean by brutally? Assaulted, and that a complaint with the jurisdiction police was registered in claim number 126 of 2021. Stop.
Our complaint is 127.
Response, the Learned Counsel for the appellant submits that it was the. Please allow me to dictate, Mr. Or you please dictate, or you tell me what I should dictate. You're reading your objection, Mr. Submitted that the appellant is in possession of the social property and that it is the respondents who attempted to interfere with his possession. Stop. He submitted that he has also lodged a complaint before the jurisdiction police against the respondents. The same is registered as claim number 121 of 2021. To stop. Next paragraph. This appeal is admitted to consider substantial questions of law, and therefore the parties cannot take law into their hands to change the status quo of the property. Stop. In that way of the matter, neither the appellant nor the respondents shall put up any construction or change the nature of the property bearing suit item number 9 bearing Kasha Ginger number 203. Ginger yav area illi ಏನು ಬರೆಯೋದಿಲ್ಲ. Suit item number 9 until disposal of this appeal. Full stop. This will not come in the way of the appellant using the suit property for tethering cattle. Tethering cattle or spoiling a haystock. Full stop. This photograph is the wool method. Site measures only about 20. 40 by 40 ಎಷ್ಟು ಸು ಕಟ್ತೀರಿ ನೀವು ಹಸು ಕಟ್ಟಿ ಅವರು ಹಸು ಕಟ್ಟಿ ಹುಲ್ ಬಣವೆ ಹಾಕಿ ವಾಟ್ಸ್ ಹುಲ್ ಬಣವೆ ಎಲ್ಲಿರುತ್ತೆ ಜಾಗ ಇದೆಲ್ಲ ಹೆಂಗ್ ಹೇಳ್ತೀವಿ ಲೆಟ್ ಯು ಪ್ರೊಡ್ಯೂಸ್ ಫೋಟೋಗ್ರಾಫ್ ಎಲ್ಲಿದೆ ಹುಲ್ ಬಣವೆ Where have you stated in your objections that there is a more course? Appellant was constructing cow shed. Is it? Sir. ಹುಲ್ ಬಣ್ಣ ಎಲ್ಲಿದೆ ಹೋದ್ರಿ? Please decide in which para. 12 ಆಯ್ತು 3 ಆಯ್ತು ಇನ್ನೆಲ್ಲಿದೆ ಹೋದ್? ಏನಾಯ್ತು? Not to change the nature of the ಅದು ಹೊಡೆದಾಕಿದೆ not to
the appellant having acquired that property, then vacant sale in the home and later he has constructed house shed and also stored his stock thereof. Thus, henceforth the later purchase.
Stop. Yes, sir. Here one of stones was stand disposed of on the above terms. One 37. ಬೆಳಿಗ್ಗೆ ಇತ್ತಲ್ಲ ಬೆಳಿಗ್ಗೆ ಇದ್ರಲ್ಲ ಆಯ್ತು. Which is that person who is in hospital? Will record the statement and close it. He is in hospital. Which hospital? Just tomorrow.
Number 52. Kumar.
SP Kulkarni, PV Manjunath. Your Dr. Jagdish. Mortgage deed was executed by whom to whom? Sampaya. Sampaya executed mortgage in favor of Abhay Reddy or Ram Reddy? Ram Reddy. What is the date of mortgage? 24/9/19. What is the time? 5 years. 5 years. So 1967. 30 years. Suit is filed when?
This right on 27/5/1999.
27/5/1999.
BLP, I have a suit for the invention and also that suit came an invention was granted that therefore this is all right. Because they think to make an application that again on Procedural, again as a fair to in a week of it's because they think this okay. Because you get limitation and without limitation by the suit filed by me, and I think and to be
Suit filed by you is for declaration.
Injection and
when was that suit filed?
Suit filed 161 of 89. That was filed on 28/8/1989.
Hello, sir. 161 is this one.
This one 163 is mine.
163 of
89.
अच्छा वो dispose आगे होगा.
So this was this is effectively 62
What is it? No. Let us go one step by one after the other. Limitation. Yes, keep a limitation. Yes, please.
limitation is 6, Article 61.
62 of transfer of property at yes.
Right now, for usufructory mortgager to cover position. The case of the usufructory mortgage, the mortgager has a right to recover possession of the property, either with the mortgage and all documents relating to property, which are in possession or power of the mortgagee, where the mortgagee is authorized to pay himself the mortgage from the rents and profits of the property, and such money is paid. Where the mortgagee is authorized to pay himself from such rents and profits, or any part thereof, a part only of the mortgage, then the term, if any prescribed for payment of the mortgage is expired, and the mortgager pays or tenders to the mortgagee the mortgage money or the balance thereof or deposits, both here provided. Or to what the Supreme Court of saying, one of the Litigation Act.
Now let us read section 61. Article 61. Word.
I am mortgager to redeem or recover possession of removable property mortgage. B. From the A melody 30 years. What the Supreme Court saying? In case of usufructory mortgage, section 61 cannot limit the operation to the land or to the account.
What do you think?
Full contingent. Is the para 2.
Now, when did you tender the amount?
Deposited the amount to be calculated.
When did you tender it to him?
He did not receive.
When did you offer it to him, Mr.? You should offer it to him, isn't it?
Yes.
When did you do that?
After a dismissal of the issue, I issued a legal notice.
1962 was a mortgage. 5 years was the limit, time limit. Did you pay the mortgage money within 5 years?
No.
Did you offer to pay?
He said, no, answer to this is not this. That's not. He told the plaintiff that he wants to continue. And so it was continued.
Who was to continue?
Or the release period, or it was continued. Mortgage, I'm sorry. Mortgage. It was continued.
But if you desire to close it, how can you say that I'll continue? What is the evidence? Say that it was extended. What is the evidence? Huh? Have you mentioned in the plaint that it was extended?
Is there are 4 of the claims are not
Yeah.
The defendant requested the first plaintiff that he wants to continue in possession of the civil property and he will intimate the same when he will seek amount for redeeming the property. Till then, he is paying the first plaintiff.
What is the reply to that? The written statement, Mr.
Perfect. They are not let any.
They not need evidence.
Yeah. Proof that they find not with this product.
Yes, please come to this paragraph number 5 of the judgment. Interim.
On second appeal. On second appeal by the plaintiff to the High Court, the matter was directed to engage with the three bench to the government. Whether the right to seek redemption would align from the daily mortgage itself, engaged to our and no time limit is fixed.
So when no time limit is fixed.
Whether there is any time limit in the case of mortgage to get each property redeemed or not. The full bench held that in the case of mortgage, limitation for recovery of position brought Limitation Act starts on payment of the mortgage money as required under Section 62 of the Property Act and not from the date of the mortgage. The relevant observations are that's all.
Yes.
And
Please read it from Para 12. Para 12.
Yes, correct. The kernel of the above provisions shows that Article 61 refers to the right to redeem or recover possession, while right of mortgagor to redeem is dealt with under Section 60 of the Property Act. The right of usufructuary mortgagor to recover possession is specially dealt with under Section 62. Section 62 is applicable only to usufructuary mortgages and not to any other mortgage. The said right of usufructuary mortgagor goes side as the right to recover possession is for all purposes right to redeem and to recover possession. Thus, while in case of any other mortgage, right to redeem is covered under Section 60, in case of usufructuary mortgage, the right to recover possession is dealt with under Section 62 and commences on payment of the mortgage out of the books or partly out of the books and partly on payment or deposit by the mortgage. This distinction is the usufructuary mortgage and any other mortgage is clearly borne out from the provisions of sections 58, 60, and 62 of the Property Act, read with Article 61 of the Security Limitation Act. Usufructuary mortgage cannot be treated on a par with any other mortgage, as doing so will defeat the scheme of Section 62 of the Property Act and the equity. This right of the usufructuary mortgagor is not only an equitable right, has statutory recognition under Section 62 of the Property Act. There is no principle of law on which this right can be defeated. Any contrary view which does not take into account the special right of usufructuary mortgagor under Section 62 of the Property Act has to be held to be erroneous on this ground or has to be limited to a mortgage other than usufructuary mortgage. Accordingly, we uphold the view taken by the full bench that in case of usufructuary mortgage, near expiry of a period of 30 years from the date of creation of the mortgage, does not extinguish the right of the mortgagor This is the ratio. And in this case, Lord, the limitation, Lord, does not come into.
Yes, sir.
Even as a period of 5 years, we are here legal staff. And the decision does not used to be coming.
But in this case, the possession remained with the mortgagor. In this case, come to paragraph number 21. This is not a usufructuary mortgage.
This is a mortgage.
In this case,
the issue of the market of judgment. The limitation act cannot.
Please read 22, paragraph 22 also.
The right of redemption of a mortgagor being a statutory right, the same can be taken.
Paragraph 22.
Yes. We thus hold that special right of usufructuary mortgagor under the Procedural Act to recover possession commences in the manner prescribed wherein, that is, when the mortgage money is paid out to rents and profits or partly out of rents and profits and partly by payment or deposit by the mortgagor. Until then, limitation does not start for the purpose of the schedule to the English Act. The usufructuary mortgage is not entitled to file a suit for declaration that he had become an owner merely on the mortgage.
What is there to show that this is usufructuary mortgage? Let us read the mortgage. D3 or D1? D3, yes. What is?
This is Narayanappa. In Sangappa. ಅವರಿಂದ 47
Form 7 ಹಾಕಿರೋ ಹೋಗ್ಬಿಡ್ತಿತ್ತಲ್ಲ. He had filed form number 7. ಚೆಕ್ ಮಾಡಿದ್ರೆ ಜಜ್ಮೆಂಟ್ ಇದೆ ಓವರ್ ರೂಲ್ ಏನಾಗಿದೆ ಅಂತ. Law is settled. Law is settled. Huh? No, no. You can have it tomorrow if you want. Huh? That is the only ground. You can't be the owner. Because the law is once a mortgage, always a mortgage. You can't be the owner. That is the only question. Please put a judgment copy. Please note it down. This tomorrow for further hearing. Friday ಆಗುತ್ತೆ sir. Last working day. Dispose ಮಾಡಕ್ಕೂ ಆಗೋದಿಲ್ಲ. Farewell is the association function. We'll come back. Sachindra Karan.
53 Sachindra Karan.
Adjournment ಹೇಳಿದ್ರು. There's no representation for the appellant and response list.
54 and Kiran Shetty.
Sachindra Karan. Shankar Narayan Bhatt. Where is Mr. Shankar Narayan Bhatt? After vacation. I can't. Right, if the other side comes, I can do it right away. Yes. Vice Kiran Shetty, where is what is it? I don't remember.
Since the plan was drafted, approachment was done by the father, and he claims a right not to share. The subject to know.
It was listed yesterday, no? Yesterday, day before. Why are you calling? Vice Kiran Shetty. Settlement again, yes, correct. What is it he wants to offer?
It is also difficult to leave out only the option. The sketchy from this. Portion in application 53 feet by 27.6.
I want to call this milestone. Phone is a phone mark. Call it from here itself. Why can't? Let us see what it says. I saw him walking around in the High Court premises. Correct.
Son of the defendant is also the party. Just 2 months back. 2 months back, my lord, some elders in the village. Not 2 months back, years back.
Please keep quiet.
In fact, my lord, some elders intervened. They were stopped for negotiations. Based on that, my lord, in fact, yesterday what I submitted, maybe 6 cents of land. To that extent, if it's looking to borrow, all the cases can be decided. That was the talks that went on. Thereafter, my lord, based on that talks, my lord, there was a survey also conducted with the intervention of the elders. Survey was conducted, my lord, and thereafter he agreed. Thereafter he didn't turn up.
But 6 cents which you have illegally occupied, you want it to be given just like that?
Illegally, in the sense, my lord, in fact, today what I understood is, my lord, in fact, he is born in that house also. From last several years, my lord, they are in that.
I think illegally occupied not by him, by maybe by his parents.
In the sense, my lord, they are brothers. Actually, in fact, they are all residing together. So that cannot be said, my lord, that is an illegal occupation because they were all residing together. Because since my lord, father was an illiterate person, his elder brother, my lord,
Is there any common ground for settlement?
because he's my lord, in fact, his father is not there, he is alone, and his mother is there. He's an auto rickshaw driver. But some reasonable this thing we can negotiate.
When reasonable. Sir, ಕೊಡೋದು ನೀವು ನಿಮ್ಮ ಕೈಲಿ ಎಷ್ಟು ಕೊಡಕ್ಕಾಗುತ್ತೆ ಹೇಳಿ.
Condition is concerned, my lord. But in fact, what had happened is my lord said to me on recent leave which was granted. In fact, my lord, in fact, his father as well as the plaintiff both had sold that 5 cents granted, which were granted initially. That was sold by these people, my lord, because his father was suffering from cancer for that treatment, my lord, that 5 cents was sold. Except this house, my lord, they don't have anything. He also underwent surgery, was in medical hospital for 2 months. He had also severe surgeries. So his financial condition is very bad, and moreover, my lord, he has to talk to his mother also. What amount they can arrange and pay. My lord, so can you treat it as partner?
It should be decided. ಇವತ್ತೇನ ಇವತ್ತು ಅವ್ರಿಗೆ ಹೋಗುವಾಗ ಅವ್ರಿಗೆ ಬಸ್ ಟಿಕೆಟ್ ತಗೊಂಡು ಹೋಗೋ ಹತ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ಇಲ್ಲ ನಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. I will not allow it to linger on. You have got so much of time, Mr. From 2009, you had time to settle. 13 years. Whatever it is, you are giving a very rosy picture. And the way you are portraying it, you know, I feel like melting down. Therefore, please come to reality. What is the practicality? He might say 101 things. If he is occupying somebody else's property, either is to vacate or is to buy it out. Buy it out only, maybe we can ask him to reduce. And sumne kodu andre who will give? For what? 6 cents. 6 cents is 3,000 square feet. 6 cents is 3,000 square feet. ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಅದಕ್ಕೆ 5 ಲಕ್ಷ ಎಷ್ಟಾಗುತ್ತೆ ಅಲ್ಲಿ
1.5 lakhs per cent. 1.5 lakhs per cent ಇದೆ ಮಾರ್ಕೆಟ್ ಅಲ್ಲಿ.
ಇಲ್ಲಿ ಇರೋದು
ಇದು ನೋಡಿ ಸರ್
1.5 cents ಇಲ್ರಿ ಸಿಗ್ತದೆ ಉಡುಪಿನಲ್ಲಿ.
ಇಲ್ಲ
ಇನ್ನೇನು ಮನೂರು ವಿಲೇಜ್. ಸರ್ ಎನಿವೇರ್ ಇನ್ ಕುಂದಾಪುರ ಟೌನ್ ಅಲ್ಲಿ ನಾನು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಜಡ್ಜ್ ಅಲ್ಲಿ ಕುಂದಾಪುರ. I am also know from that place because I virtually almost every month I am there. I am again going on 25th. So I get information. Elladru property ಏನು ಎತ್ತರ ತಿಳ್ಕೊತೀನಿ ನಾನು. And Brahmavara we are establishing report shortly. ಬ್ರಹ್ಮಾವರದಲ್ಲಿ ನಾವೆಲ್ಲ ತಿಳ್ಕೊಂಡಿದ್ದೀವಿ ಎಷ್ಟಿದೆ ರೇಟು ಏನು ಎತ್ತ ಬಾಡಿಗೆ ಎಷ್ಟು.
This comes in between Brahmavara and Kundapura. There may not be from highway we have to get inside.
Inside ಅಂದ್ರೆ ಸಮುದ್ರ ಬರ್ತದಲ್ಲ ಇನ್ಸೈಡ್ ಹೋದ್ರೆ ಸಮುದ್ರ. ಕರೆಕ್ಟ್.
This road leads to Holland side and that. So ಅದು ಒಳಗಡೆ ಹೋಗ್ತದೆ. So interiors ಅಲ್ಲಿ ಇದೆ. ನಮ್ಮ ಟೌನ್ ಅಲ್ಲಿ ಕೆಲವು ಕಡೆ 1.5 ಲಕ್ಷ per cent ಇದೆ. It's not in the town. It is.
ಆಯ್ತು, ಒಂದು ಕೆಲಸ ಮಾಡಿ 5 ಲಕ್ಷ ತಗೊಂಡು ನೀವೇ ಬಿಟ್ಬಿಡಿ.
ಹೈವೇಗಾಗಿ they have acquired the land. Portion of the land. 4 cents is already gone for the highway.
ಇಷ್ಟು ಬೇರೆ ನ್ಯಾಷನಲ್ ಹೈವೇ ಚೆಕ್ ಬಂದಿ ನ್ಯಾಷನಲ್ ಹೈವೇ ಕಣ್ರಿ 17. So this 20 cents will not be away from the highway. It will be just near the highway. And the way you are saying it is interior of the highway. Take 5 lakhs and get out. Take 5 lakhs and get out. ನೋಡ್ರಿ, ಏನು ಇಲ್ದಿರೋದಕ್ಕಿನ್ನ ಸ್ವಲ್ಪ ತಗೊಂಡು ಹೋಗೋದು ಬುದ್ಧಿವಂತಿಕೆ. ಬರೀ ಕೈಲಿ ಹೋಗೋದು ಬದಲು ಏನೋ ತಗೊಂಡು ಹೋಗೋದು ಬುದ್ಧಿವಂತಿಕೆ. ನೀವು ಹಿಂಗಂದ್ರೆ ಏನ್ ಆಗೋದಿಲ್ಲ. ಕೋರ್ಟಲ್ಲಿ ದಾಖಲೆ ಏನಿದೆ ಅದ್ರ ಪ್ರಕಾರ ನೋಡ್ ಮಾಡ್ತೀವಿ. ಅದೇ ತರ ಮಾಡು ಅಂದ್ರೆ ನನಗೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ. ಒಂದ್ 5 ನಿಮಿಷ ಬರ್ದು ಕಳಿಸ್ತೀನಿ. ನೀವು ಹಣೆ ಬರ ಬರೆದ್ಬಿಡ್ತೀವಿ ನಾವು. ಅದ್ರ ಬದಲು ಏನಾದ್ರು ಒಂದ್ ದಿನ ತಗೊಂಡು ಹೋಗೋದಕ್ಕೆ ಸ್ವಲ್ಪ ಬುದ್ಧಿವಂತಿಕೆ ಉಪಯೋಗಿಸಿ. 5 ಲಕ್ಷನೋ 10 ಲಕ್ಷನೋ ಬಂದ್ರೆ ನಿಮ್ಗೊಂದು ಇನ್ನೊಂದು ಆಟೋ ಸಿಗುತ್ತೆ, 2 ಆಟೋ ಸಿಗ್ತದೆ. ಏನೋ ಇದ್ರೆ ಮುಂದುವರ್ಸ್ಬೋದು. ಏನು ಇಲ್ದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ? ಏನು ಇಲ್ದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ? ಮನೇನೂ ಹೋಯ್ತು, ದುಡ್ಡು ಹೋಯ್ತು. ಬಂದಾಗ ಉಪಯೋಗಿಸ್ಕೊಳ್ಳಿ. ಎಸ್, ಆರ್ ಯು ವಿಲ್ಲಿಂಗ್ ಟು ಸೆಟ್ಲ್ ಇಟ್?
ಮೊನ್ನೆ ನಮ್ಮ ಸಮಾಜದ ಕಡೆಯಿಂದ ಒತ್ತಾಯ ಮಾಡಿಸಿ ಕಾರ್ಯ ಮಾಡಿಸ್ತೀವಿ. ಇಂಥ ದೊಡ್ಡ ಮನುಷ್ಯನಿಗೆ ಆಗ ಒಂದು ಸಮಾಜದ ಒಂದು ಬೆಳೆ ಕೊಟ್ಟು ನೆಗೋಷಿಯೇಷನ್ ಹೋದ್ರೆ ಯಾವೇನ್ ಮಾಡ್ಕೊಟ್ಟು ನಮ್ಮ ಅಪ್ಪನ ಆಸ್ತಿ ನಮ್ಮ ದೊಡ್ಡ ನಾಯಕರು
ಹೌದಪ್ಪ, ನಾನು ಹೇಳುದು ಹೊರಗಿನವ್ರು ಯಾರು ಬಂದು ಎರಡು ಹೊಡೆದ್ರೆ ಅವ್ರ ಜೊತೆ ನಗ್ನಗ್ತಾ ಹೋಗ್ತೀರಿ. ಅಣ್ಣ ತಮ್ಮ ಒಂದೇಟು ಹೊಡೆದ್ರೆ ಕೋಪ ನೋಡ್ತದ? ಆಯ್ತು ಹೇಳಿದ್ದು, ಅಣ್ಣ ತಮ್ಮ ಜೊತೆ ಆಯ್ತು ಮಾಫಿ ಮಾಡಕ್ಕೆ ಯಾಕೆ ಬರೋದಿಲ್ಲ? ಆ ದೊಡ್ಡ
ಸಭೆ ಮಾಡಿಸಿ
ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ರಾಜಿ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ, ನಾನು ತೀರ್ಮಾನ ಮಾಡ್ತೀನಿ. ರಾಜಿ ಆಗೋದಿಲ್ಲ ಅಂತ ತೀರ್ಮಾನ ಮಾಡ್ತೀನಿ. ಇದೇ ತರ ಇದು ಒಪ್ಪಿಲ್ಲ ಅಂತ ನಾವು ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಒಂದ್ಸತಿ ಬರದ್ಮೇಲೆ ಅದು ಅಳ್ಸಕ್ ಆಗೋದಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತೀವಿ. ಅದ್ರಲ್ಲಿ ತಿಳ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಆಗಲ್ರಿ. ಕೋರ್ಟ್ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಒಬ್ರಿಗೆಲ್ಲ, ಅವ್ರಿಗೂ ಇದೆ ಕೋರ್ಟ್ ಅಂತ. ನಿಮಗೆ ಕರ್ಸಿದ್ದೆ ಅದು ಆ ಉದ್ದೇಶಕ್ಕೆ. ಅದು ನಿಮ್ಮ ವಕೀಲರು ಹೇಳಿಲ್ವ ನಿಮಗೆ? ಹೇಳಿದ್ರು ಇಲ್ಲ? ಏನಂತ ಹೇಳಿದ್ರು? ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕು ಅಂತ ಇದೆಯಲ್ಲ, ಹೇಳಿದ್ರು ಇಲ್ವ? ಮತ್ತೆ ನೀವು ಅದನ್ನ ಯೋಚನೆ ಮಾಡಿ ಬರ್ಬೇಕಲ್ವಾ? ಮತ್ತೆ ಬಿಡಿ, ಆರ್ಗ್ಯೂಮೆಂಟ್ ಮಾಡೋ. ಈಸ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್. ಪ್ಲೀಸ್ ಆರ್ಗ್ಯೂ. ಕೂತ್ಕೊಳ್ಳಿ, ಕೂತ್ಕೊಳ್ಳಿ. ಮಾತಾಡುವ. Yes, B. Ramesh Vishwanath Reddy. Wait.
Inspection to engage the CH-23.
ಯಾರು ಕೇಸ್ ರೈಸ್ ಇಮಿಡಿಯೇಟ್. Ready? Why are you saying? Why are you objecting? If you are ready, I'll ask him to argue. You ready? Huh? Yaru? Ready? ಆಯ್ತು ಹೇಳಿ, ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಆರ್ಗ್ಯೂ ಮಾಡಿ. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಏನಿರುತ್ತೆ ರಮೇಶ್?
This property has been developed. Because father executed will which can take care of brother. Because after the lapse of earlier, because he attained majority, he files a suit, son files a suit. The suit is decreed. Subsequently, the brother who has sworn property in care of the appellant files a regular appeal. Because in the regular appeal, they enter into a compromise.
Because you did not challenge it.
Because I challenged it by proceedings, also find an RE. Because I was not issued any notice. I am a purchaser.
You filed an RA.
Yes, sir.
What happened to that?
Subsequently, challenging the compromise decision, this RSA was also filed. Since I was prosecuting this, I withdraw that to the legal people
So this appeal is only against the compromise.
Compromise and the judgment and decree. Both are done.
But how can you do that without going before the first appellate court?
First appellate court was filed. Since this appeal was entertained and after arguing.
Should have filed an appeal before the first appellate court. Why do you withdraw it? This is against the compromise, Mr. And there's no challenge to the final, the original decree passed in the suit. There's no challenge to that. How can you file an appeal? How is this appeal maintainable? Then you should go before the same court. And you should say that I was not a party, so therefore acceptance of the compromise affects my right. Allah Bahai. First, will give you liberty to go before the same court and challenge the compromise. So this will be the same effect, whether you do it today or after vacation. The effect will be the same. Whether you go before the same court and say that this compromise is not binding on me.
The seats for the partial decree. In respect of the suit schedule property, that is agriculture land. Agriculture is right. Where the native says that I want to pay this.
There is a decree which stays in your face. That is passed to the trial court. There's a decree, right or wrong, there's a decree. One of the defendants filed an appeal. They reported a compromise. You saw the compromise happening in here, but still you did not resist. Now you come before this court and I do. Now you have come to know that the parties have amicably settled the dispute. But how can you challenge that compromise in this appeal before the High Court? And also the decree passed by the trial court. ಅದು withdraw ಮಾಡಿದ್ರಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಅದು ರಿಪೇರಿ ಮಾಡಿಸ್ಕೊಂಡ್ರೆ ಸರಿಯಾಗಿ ಮಾಡ್ಕೊಳ್ಳಿ. Take advantage of the pendency of the second appeal and do the repair. As a request of the council for apparent discount for vacation. This. ಇದು 56. There is no representation for the appearance in response list of the case. 58. Theory. Vigneshwara, you. Even appeal against R4 is abated. Appeal against R4 is abated. Who is R4? Who is R4 before the trial court? Then, no, but what is the R4A, R4B, R4C, R4D and D? Abatement, set aside agilva, abatement.
Sir, 11/3/2020, I have filed notice
Notice issued to R4 is returned as is deceased. Appeal is abated. Which time is granted? Yes, you brought the LRs on record. Yes, Mr. Vigneshwara, you are. You ready, Lwa? But ಏನ್ ಮಾಡ್ತೀರಿ ಕೇಳ್ಬಿಟ್ಟು ತಿರ್ಗಾ I can't even treat it as parted.
Very small question to be.
ಇಲ್ಲ ಅಂದ್ರೆ I'll decide it, record his absence and just.
I request the court to look into the appeal memo along with the judgment. There is a clear acknowledge.
Yes, please.
One Narsapai was the propositor, his son Adho Ainala, who is the defendant number one. And he had 6 children. Narsimpai, Karnataka, Krishna Pai, Venugopal Pai, Damoдар Pai, Lalita Pai. Venugopal Pai, Damoдар Pai, and Lalita Pai. The Damoдар Pai D1, and Venugopal Pai D2, Lalita Pai D3. Plus the children of Madhav Pai's the father. Father is named is Sharda Paiya, Narsim Paiya, wife Sharda Pai. Our one name is. Suit is one for partition. But the trial court has granted 1/6 share insofar as one property is concerned. I draw the attention of the court to page number 82. The suit of the plaintiff is declared in part to the effect that they are entitled for 1/6 share in suit item number 1 and 5/12 share in item number 2 of each scheduled property. It is made clear that the schedule that the defendant 1A are entitled 5/6 share in the suit items 1 and 7/12 share in the suit item number 2 of each schedule. This is what? This is confirmed by first appellate.
Why this 5/12 in item number 2?
One of the brothers had executed a will without the exact extent. So remaining portion of Puna family ke bartade. Ivra 1/6 share ga ನಾವು ಇಲ್ಲಿ ಮಾಡೋದು ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಬರ್ತಿದೆ.
So far as item number 1 is concerned, I don't think you will have any quarrels.
I will explain it. That is the point. That's all the point. Will ಮಾಡುವಾಗ ಅದರಲ್ಲಿ ನಮಗೆ ಒಂದು ಅದು
ಯಾರು ಯಾರಿಗೆ ವಿಲ್ ಮಾಡಿದ್ರು?
D1 ಗೆ
ಆದೋಪಯ್ಯ
Venugopal Pai in favor of Damodar Pai has executed a will. Exhibit D2.
He can only execute his 1/6 share.
He can, but what he has given is in cents. So it will not amount to his total 1/6. Our remaining portion is the Hage.
Damodar Pai has got only 1/6. How can you will it away in the form of cents? His 1/6 alone has to be disposed of.
1/6 is the poor will money.
Correct. Finally, decide ಮಾಡ್ತಾರೆ ಆ 1/6 ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ.
ಹೌದು, remaining portion ಇದೆಯಲ್ಲ, ಈಗ suppose hypothetically if 1/6 share becomes 6 cents, then he can give 6 cents. If he wills away 4 cents, or remaining 2 cents will go to the entire family.
Correct.
So ಅದನ್ನ ಹಾಗಾಗಿ partition has to shares ಆಗಿ divide ಆಗುತ್ತೆ. My submission is that only one point, my lord. Exhibit D1 is the release deed executed by 2 persons in favor of Damodar Pai. D1 in respect of their undivided share.
There are 2 persons here.
That is
Padmanath Pai and my lords, Padmanath Pai, Krishna Pai. My lords, and Lalita Pai had exported yet another release deed in favor of P1 Damodar Pai. So both the courts have held this release deed is to the benefit of P1. Therefore, he is entitled. But the position of law is otherwise. If without the consent of the other co-partners, if there is any release, then it would ensure to the benefit of the entire family, not to that alone. That is the position of law. So therefore, the courts below have erred in holding that it is exclusively belongs to defendant number or defendant number one. It belongs to me also.
So what does the release deed say?
It is released in favor of the Damodar. It towards undivided share of the family.
Then what is it?
Yes.
Ready, Vijayamas? You are ready?
No, I'll have to point to the may I draw the attention of the court to page number 58 issues. I first take the last to the issues. Whether the defendant proves that Padmanath Pai and Lalita Pai and Krishna Pai released their right to claim properties in favor of first defendant Damodar Pai under release deed dated 29/1985 and 7/10/1988. Whether the first defendant proves that the will dated 24/1/2000 executed by defendant number 2 is true and valid. These are all the only 2 points I will consider. Rest and balance is not required. But now I draw the attention of the court directly to paragraph number 13, page 61. The foremost condition of defendant number 1 is claiming rights of the property. This is Padmanath Pai and Lalita Pai as well as Krishna Pai by virtue of judicial release date 29/1985 and 7/10/1980 respectively. She is so and so the learned counsel for the plaintiff argued that the plaintiff failed to prove the execution of such deeds and same are behind the back of plaintiffs. As submitted by the learned counsel, natural the heavy burden is upon Beacon 1A and 1D to prove the said defense. In order to prove the same, the defendants render upon the total restorer D1, 2, 5, and 6, coupled with the exhibit D1 and D3. Based upon such testimony, it is the argument of so-and-so, the learned counsel for the defendant number so-and-so, that they have proved the execution of these material documents and claim the share of this is Padmanath Pai and Krishna Pai as well as Lalita Pai by virtue of D1 and D3. In the light of their arguments, I have carefully scrutinized the evidence of defendants in the context of proof of these statements. PW1 Shanti Pai is nothing but wife of Damodar Pai. In her evidence, she deposed that Padmanath Pai and Lalita Pai have jointly executed a release deed in the year 1985 and thereupon relinquished their 2/6 share in suit civil properties in favor of her husband Madhav Pai. She stated that Padmanath Pai has died in the year 1988. Further, she deposed that Krishna Pai was also executed another registered release deed in the year 1988, relinquishing his legitimate share in the suit properties in favor of her husband. In support of her oral say, coupled with readings produced D1 and D3, which are very original registered release deeds dated 29 sides of all careful scrutiny of these registered documents, the exhibit D1 appears to be executed jointly by Padmanath Pai and Lalita Pai, the son and daughter of late Madhav Pai in respect 7 number 1/6 to the extent of 0.28 acres to the extent of their share in it. However, the said release did not recited item number 2 of these scheduled properties. During the course of cross-examination, she proves that in the year 1988, she got married with Damodar Pai. The exhibit D1 and D3 are held on record after her entry to the family, and thereupon she is competent witness to speak about these documents. No doubt, as pointed out by the learned counsel for the other side, she was not a party to the said exhibit D1 and D3. However, nothing has been elicited to deny her evidence are supported by registered document evidence, D1 and D2. But then there is no specific level of execution of these registered document by plaintiffs in their appeal. Anyhow, the defendant made efforts to prove the execution of these document evidence by reducing the of CCA. Even if I while announcing the respect of witnesses, the court held that these documents are true. So, to that extent, my share was reduced. I submission to the court. The release deed exhibit D1 and D3 does not allude to the benefit of only to the release, but it alludes to the benefit of whole family.
Okay, therefore, read the release deed. What does it say? He can release it in favor of the family, he can release it in favor of one person.
No, even if it is undivided share of funds, even if it is released in favor of one person, it would allude to the benefit of.
Of course, document was.
Let's exhibit D1, my lord. Yes. ₹1,000 ಸ್ಥಿರಾಸ್ತಿ ಕಟ್ಟಲು ಹಕ್ಕು ಕ್ಲಾಸ್ ತಾರೀಖು 20 ಸೆಪ್ಟೆಂಬರ್ 2023 ಪುತ್ತೂರು ತಾಲೂಕು ತಿನ್ನಂಡಿ ಮಧೋಪೈಗಳ ವ್ಯಾಪಾರಕ್ಕೆ 37 ವರ್ಷದ ದಾಮೋದರ ಪೈಗಳಿಗೆ ಸತ್ರಿ ತಾಲೂಕು ತಿನ್ನಂಡಿ ವ್ಯವಸಾಯ ಮಾಧವಪೈ ಮತ್ತು 16 ಪ್ರಾಯ 39 ವರ್ಷ ಪ್ರಾಯ 2 ಮಕ್ಕಳು ಸ್ಥಿರಾಸ್ತಿ ವಿಷಯ ಹಕ್ಕು ಖುಲಾಸೆ ಪಡ್ತಾರೆ. ಈ ಕಡೆ ಸ್ಥಿರಾಸ್ತಿ ನಮ್ಮ ತಂದೆ ಮಾಧವಪೈಗಳು ಮಾಧವಪೈಗಳ ಅಕ್ಕಿ ಇದ್ದು ಸಕ್ರಿಯ ಆಸ್ತಿಯಲ್ಲಿ ಅವರು ಮತ್ತು ನಮ್ಮ ತಾಯಿ ಸಂಜೀವನವರು ಮೃತಪಟ್ಟರು. ನಮಗೆ ನಮಗೆ ಮತ್ತು ನಮ್ಮ ಸಹೋದರ ನರಸಿಂಹ ಪೈ, ಕೃಷ್ಣ ಪೈ, ವೇಣುಗೋಪಾಲ್ ಪೈ ವಗೇರೆ ಕೂಡ ವಿಷಯ ಹಕ್ಕು ಇರುತ್ತದೆ. ಸಕ್ರಿಯ ಆಸ್ತಿಯು ಸಣ್ಣ ಆಸ್ತಿಯಾಗಿ ನಮಗೆ ವಿಷಯ ಹಕ್ಕು ನಿಮಗೆ ಬಿಟ್ಟುಕೊಡುತ್ತೇವೆ ಎಂದು ಹೇಳಿದ್ದೇವೆ. ನೀವು ಸಮರ್ಪಕ ಪ್ರತಿಫಲಕ್ಕೆ ಪಡೆಕೊಳ್ಳಲು
ನಿಮಗೆ ಬಿಟ್ಟು ಕೊಟ್ಟರೆ ಮನೆಗೆ ಅಂತ ಹೇಳಿದ್ರು. ನಿಮಗೆ ಬಿಟ್ಟು ಕೊಡುತ್ತೇವೆ ಎಂದು ಹೇಳಿದ್ದಕ್ಕೆ
ಅದನ್ನ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಇದನ್ನ ನನಗೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. But similar effect is the another exhibit D3. ಅದು ಆಮೇಲೆ ಹಾಗೆ ಬರ್ತಿದ್ದಾರೆ ಆಲ್ಮೋಸ್ಟ್ ಸೇಮ್ ಕಾಪಿ. Same copy. There is no difference. In this regard, I am relying on the judgments. What is it?
It's all right, pass it on, it's all right. Yes, please go on.
Now I draw the attention of the court to the first judgment. Tamma Venkateswamy dead by LRs, Tamma, Rattamma and others, my lord. That is reported in AR 1987 Supreme Court 1775. 1987 Supreme Court 1775.
What are the facts in this case?
Similar set of facts, my lord, where release date, etc. was. What? Shall I take your lordship directly to the concerned parameter?
Read the facts first.
Is it? There are two, my lord. In order to consider the point, it is necessary to state a few relevant facts. Two brothers, Amility and Vigality, and the sons and daughters of Peter, the respondents number 2 to 7 here in constitute joint Hindu family governed by the Judicial School of Hindu Law. On May 4th, 1959, Amility executed a deed of settlement, Exhibit A1, in favor of his brother Vigality, conveying his entire undivided interest to the Gopal family, serving a life interest to him, and also providing that after his death, his brother should maintain his wife. Amility died in January 1965, and shortly thereafter, his brother Vigality also died in March 1965. It appears appears that after the death of Rami Reddy, difference arose between widow and the respondent number 1, as a result of which the widow of Rami Reddy, since deceased, demanded the partition of her husband's share, which was gifted by her husband to his brother Veera Reddy. Thereafter, she filed a suit out of which this appeal arises for partition and recovery of her husband's share after cancelling the deed of settlement, Exhibit A1. Internally, on the ground that it was void document under Hindu law, the suit was contested by respondent number 1 to 6. The respondent 3 filed a written statement denying the claim delegation. The other respondents adopted the written statement of respondent number 3. So this is the basic facts. Now the position of law that is being under paragraph number 20, page number 12, coming page number 12. Coming back to the facts of the case, we find that Rami Reddy made gift for the common benefit of Dhoni as well as his sons as held by High. It is submitted on behalf of the respondent that really it is a case of renunciation or relinquishment by Rami Reddy of his interest in favor of his brother and his sons. It was the intention of the donor that the property might be enjoyed by his brother and his sons, and accepting that the donor had reserved to himself a life interest presumption for its maintenance, he gifted his entire interest in the personal property to his brother. There is some force in the contention of the earlier counsel for the respondent that the gift will be construed as relinquishment or renunciation of its undivided interest by the donor in favor of the other co-person. Although the gift is ostensible in favor of Veera Reddy, but really the donor meant to relinquish his interest in the co-person in favor of Veera Reddy and his son. In this connection, we may refer to the following passage from Mullah's Hindu law, 15th edition.
Here, Veera Reddy and his sons formed a co-personally.
Allah, our brother.
Yeah, Veera Reddy is the brother.
Veera Reddy, brother who gifted money. Veera Reddy was our monthly.
Rami Reddy executed a gift deed to Veera Reddy. Question is whether the gift is only to Veera Reddy or to his sons also.
Rami Reddy and his Allah India Matra. They constitute.
No. The answer is Rami Reddy executed a gift deed to Veera Reddy. The question is whether the gift was only to Veera Reddy or to Veera Reddy and his sons.
Next concept was 264, Article 260. Renunciation or relinquishment of his share. A co-partner may renounce his interest in the co-partner property in favor of other co-partners as a body, but not in favor of one or more of them. If he renounces in favor of one or more of them, the renunciation enables for the benefit of all other co-partners and not for the sole benefit of the co-partner or co-person in whose favor the renunciation is made. Such renunciation is not invalid even if the renouncing co-person makes it a condition that he would be paid something towards maintenance. The renunciation of relinquishment must of course be genuine. If fictitious and not acted upon, it would not be operated as between the parties and partition can be paid. Assuming that it is a renunciation in favor of one of the co-partners, namely Veera Reddy, such renunciation enables to the benefit of all other co-partners and not for the sole benefit of co-partners whose favor the renunciation was made. In our view, the gift made by Rami Reddy to Veera Reddy should be construed as renunciation of his undivided interest in the co-partner in favor of Veera Reddy and his son, who were the remaining co-partners. The gift was therefore valid, construing the same as renunciation or relinquishment by Rami Reddy of his interest in the co-person, and accordingly consent of the other co-person was immediate. Well, my submission for this is here. One of the brothers got the two released exhibit B1 and B. My submission is it will be to the benefit of joint family because it's undivided share. Yes. It is not that we cannot have been shared. But the next judgment is Next judgment in page number, it starts at page number 13, my lord, 1936-38 Bombay Law Report 1238. Well, I draw the attention of the court to directly para number 9, my lord, page number 15. What is the effect of this renunciation upon the status of other members of family? It is argued that when one member of a joint family separates from the other members, his separation operates as separation of all the members of the family from one another. In many cases, it may be necessary in order to ascertain the share of the outgoing member to fix the share which the other co-partners are or would be entitled to. And in this sense, subject to the question whether these others have agreed to remain united or to reunite, the separation of one is said to be virtual separation of all. So it's a case reported. It is settled rule that when the member of a family holds the family estate in defined share, they cannot be held to be joint in estate. But no definement of share need take place when the separating member does not receive any share in the estate but renounces his interest clearly. His renunciation merely excuses his interest in the estate, but does not affect the status of the remaining members who had the family property, and they continue to be co-partners as before. The only effect of renunciation is to reduce the number of persons to whom share would be allotted and when a division of the estate takes place. Not the next judgment is my lords. Page number 19, my lords. This is again Supreme Court. This is Himachal Pradesh judgment, my lord. I draw the attention following the same principle, my lord. More or less same principle, we could value to the benefit of the entire family. Paragraph number 7, my lords. Paragraph number 7 starts at page number 20, my lords. Yes. Several judgments have been relied on. However, the learned senior counsel appearing for the plaintiff appellant by placing reliance upon judgment rendered by the Honorable Madras High Court in this title so and so, reported so and so, relevant paragraph 12 to 14, and whereof are expected thereafter. I'll read that. A co-person can renounce his interest in the joint family estate. The renunciation does not result in general partition of the family. Such a renunciation merely extinguishes his interest in the estate, but does not affect the status of the remaining members quoted the family property, and they continue to be co-partners as before. The only effect of the renunciation being to reduce the number of persons to whom the shares would be allotted. If and when a division of the estate takes place, a co-person can renounce his interest only in favor of all the co-persons, and when he renounces in favor of only one of them, the renunciation endures for the benefit of even the others. His renunciation, which endures for the benefit of all the other co-persons, will take the form of a gift of the entire interest of co-person in favor of another co-person. In Mullah, same thing, a lot of Next, 14. In a full-time decision of this court reported in so and so, the relinquishment by one co-partner of his interest in the family estate in favor of members of co-partnership does not amount to an alienation. It merely amounts to an extinction of his interest in favor of others. The gift of this interest to one of several other co-partners would not mean extinction of that interest. It would mean an alienation of it. It is well settled law that there cannot be such gift to stranger. And it is now clear that there cannot be gift to a fellow co-partner if the family is to remain undivided. There is another Privy Council judgment which supports the proposition that there cannot be a renunciation by one member of joint family in favor of of several other members of the family while the family remains done. In was a so and so case, one father of who executed release in interest of his interest in the family property in favor of his father. The on the High Court held that release must be treated as being not for the benefit of the father alone, but the co-partnering and the shared share to be determined as to father of at time. This case went to privy council as the so and so, they are not declaring that governing principle had been rightly applied by the High Court and dismissed the appeal. Page number 497 sentencing of so and so. The rights on cannot be considered good law, especially after the decision of pre-consideration so and so. It follows from what we have said that we are in full agreement with this opinion and that additional support for it is to be found in the judgment of their lordship in case of so and so. The answer which we give to the question referred is a member of Hindu family governed by natural law cannot give his interest in the family estate one of several properties which they remain joint in estate. In such circumstances, he relinquishes his interest, but the relinquishment offers for the benefit of all other members. The cost of this reference will be cost in the appeal. Well, it is held in the same way, my lord, next paragraph also. But then, my lords, another judgment at page number 23, again, judgment of High Court of Judicature at Madras, taking cue from the first judgment, that is Tamma Venkatamma's case. Sorry, Tamma Venkata Subhamma's case. Saying they have held that the release, if any, would be renewed to the benefit of all the members.
So, should we not look into the facts of each case?
Each case is present.
For example, Tamma Venkata Subhamma was a release like a brother in favor of this another brother. So the question is whether in this case, in the case on hand, that was not a case where the release was in favor of the other members who are not the beneficiaries of the release. Correct. Release ಕೊಟ್ಟಿಲ್ದಿರೋ ಬ್ರದರ್ಸ್ ಅವ್ರಿಗೆ ಸೇರ್ತದ ಅವ್ರ ಮಕ್ಳಿಗೆ ಸೇರ್ತದ ಅನ್ನೋದು ಕ್ವೆಶ್ಚನ್ ರಾಮಸುಬ್ರಹ್ಮಣ್ಯ ಬಂದಿದೆ.
ಮತ್ತೆ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಅದನ್ನೇ ಹೇಳಿದ್ದಾರೆ. ನ್ಯೂಸ್ ಟು ದ ಬೆನಿಫಿಟ್ ಆಫ್ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಸ್ಪೆಸಿಫಿಕ್.
This Hindu Mullah law says the same thing.
So therefore, this release is what has been executed by the other defendants in favor of D1 does not endure to the benefit of D1 alone. It will endure to my benefit as well. Those people who have executed the release are out of the family. They got their share, they are out. They are given it up. That is dependent number. Lalita Pai, Padmanath Pai, Krishna Pai and Lalita Pai. Padmanath, Krishna Pai, Lalita Pai. ಇವರು 3 ಜನ ರಿಲೀಸ್ ಮಾಡಿದ್ರು. ಅವರು 3 ಜನ ಹೊರಗೆ ಹೋಗ್ತಾರೆ. ಇಲ್ಲಿ ಉಳಿದಿರೋರಿಗೆ ಶೇರ್ ಜಾಸ್ತಿ ಆಗಿದೆ. So that is what the courts have held. This aspect was not considered either by the trial court or by the High Court. I mean, sorry.
But the problem is in this case, release is for consideration.
Maybe.
This is for consideration.
Maybe. Even if it is for consideration, that is what the judgment said. Even if it is for consideration, still, in Venkata Subhamma case, gift deed consideration, but love and affection is the consideration. But therefore, in that case, the court held that it has to be construed as release, and therefore it goes to the benefit. So here, even assuming that there is a money that is paid by releasing it, it was joint fund, my lord. There was no separate fund, it was not divided. So now they cannot feel that it is not my personal, because it was entirely joint family property.
What are those properties?
Lord, it's landed property in the last year.
What are the suit properties?
That is, item number 1 is 28 cents of land, my lord. And item number 2 is about 1 cent of land. That's all. ಒಟ್ಟು 29 ಸೆಂಟ್ ಜಾಗ. ಒಂದು 10, 11 ಗುಂಟೆ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ, 11 ಗುಂಟೆ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ. Next could be next limb of argument.
So obviously this is not used for agriculture.
Yes.
So where is the question of income from this property?
There is jump. Income ಅಲ್ಲಿ ಅವರು ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು ಹೇಳಿಲ್ಲ, ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ. ಬೇರೆ ಸೈಡ್ ನಲ್ಲಿ ಇದ್ದಾವಲ್ಲಿ ಬಾಡಿಗೆಗಿದ್ದು ಅವರು ಒನ್ ಆಫ್ ದಿ
evidence ಇದೆ. Where is the evidence for that?
No, there is no evidence. I am saying straight away, there is no such evidence or anything on that. Whether there is income or not would not be an issue. When the entire family remained as that, it is like one pocket. Although nobody of the eldest, that is dependent one, is the karta. He holds it in trust with others. So now it cannot be said that no, it is my independent income. No, that cannot be stated. That is first. But the next limb of argument is in respect of the bill. Bill executed by one of the co-partners in favor of event number 1. But I am reading the suspicious circumstances for these 2 reasons. Number 1, he was a drunkard. Admittedly, he was a drunkard. That has come in evidence. Secondly, he was residing in the township of the defendant number 1 on rental basis. Rental basis or free of basis, that is not exactly come. It is so he was at the mercy of defendant number 1. Under these circumstances, I submit before the court, neither the first appellate court or the trial court had not decided the suspicious circumstances under which the will came into picture. Within 3 months of the execution of the will, the executor had died. So these are the 2 grounds on which I rely for demonstrating before the court that the will has come up in suspicious circumstances. Well, in this regard, issue number 2 by law. Page number.
ನಾಳೆ ಹಾಕ್ತೀನಿ. There is no representation for the respondent. Counsel for the appellant is heard. It's tomorrow for further argument. ಆಯ್ತಾ? ಎಷ್ಟು ಕೊಡ್ಬೇಕು? ನಿಮ್ಗೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕು? How much will you take and leave? So what he says, 5 ಲಕ್ಷ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಆಯ್ತಪ್ಪ, ಇವಾಗ 5 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ರೆ ಅದು ಖಾಲಿ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. Find a way out, mister. There's an amicable settlement is always better. It makes sense. At least the poison will come down. The heat will come down.
ಇಲ್ಲ ಸರ್.
ಆಯ್ತು 13 ವರ್ಷ ಇನ್ನ 10 ವರ್ಷವರೆಗೆ
ನಾನು ಹೇಳಿದ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲಪ್ಪ ಇನ್ನು 10 ವರ್ಷ ಹೊರಗಡೆ ಇರ್ತೀನಿ ಅನ್ನಂಗಿದ್ರೆ ನಂದೇ ಅಭ್ಯಂತರ ಇಲ್ಲ. ಈ ಪೊಸಿಷನ್ ತಗೊಳಕ್ ಇನ್ನು 10 ವರ್ಷ ಬೇಕಾಗ್ತದೆ. If you want to take the risk, you please consider. ಪೊಸಿಷನ್ ತಗೊಳಕ್ ಇನ್ನು ಎಷ್ಟು ವರ್ಷ ಯೋಚನೆ ಮಾಡಿ. ಆಮೇಲೆ ಉಡುಪಿನಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ 5 ವರ್ಷ ನಡೀತದಲ್ಲ. So be practical. Be practical. 3,000 ರೆಡಿ ಇದೆ. ಮೇನ್ ರೋಡ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ you know what is the rate of rent? ರೆಂಟ್ ಎಷ್ಟು ಜನರೇಟ್ ಆಗುತ್ತೆ? 60 ರೂಪಾಯಿ ಇದೆ ಅಡಿಗೆ ಮೇನ್ ರೋಡ್ಗೆ. ಇಲ್ಲ ಬರುತ್ತೆ, ಕೊಡ್ಬೇಕು ಅಂತ ಬಂದ್ರೆ ಬರುತ್ತೆ. ಅದೆಲ್ಲ ಕೊಡಬಾರ್ದು ಅಂದ್ರೆ ಬಂದ್ರೆ ಇನ್ನೇನೋ ಬರುತ್ತೆ. So 5 lakhs, you want to settle it or not? Think about it. 5 lakhs put close mark. Either you take 5 lakhs or leave 5 lakhs. Either of the two. ಅಷ್ಟೊಂದು ಕಷ್ಟ ಇದ್ರೆ 5 ಲಕ್ಷ ತಗೊಂಡ್ಬಿಡ್ರಿ. You seem to be in lot of difficulties financially. He is willing to pay 6 lakhs. ಈ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಯಾವುದೇ ಕೇಸ್ ಇದ್ರೂ ಈ ವಿಡ್ರಾ. ಯಾವಾಗ? ನಾಳೆ. ಚೆಕ್ ಕೊಡಿ. ಪೊಸಿಷನ್ ಚೆಕ್ ಯಾವಾಗ? In vacate. Is it a pakka construction or a And we will fix a date for compliance. File the terms of settlement. We'll fix a date for compliance for handing over key and to hand over the check. Do it. File a memo. This tomorrow. They have to be present. They have to sign the order sheet. Can come at 10:30 itself if the memo is ready. When early. Next.
Your Lordship, I am for the appellant.
Yes.
I request your Lordships to have the matter after vacation, Your Lordship.
The request of the council for appellant. Only time agala keltidra 4:20 ಈಗ time. At the request of the council for appellant list after vacation. Next.
Number 68 and 61. Withdrawal.
My lord, I appear for the respondent, please, my lord.
Yes, please.
My lord, I request for a date, please, my lord.
The request of the council for appellant list after vacation. There is no representation for the appellant and respondent list after vacation.
65. PA Bediyappa.
Same on.
63.
I appear on behalf of the appellant, my lord.
Yes, madam.
Pray for time, my lord.
Madam, this gentleman is waiting since morning. You don't have the courtesy to tell him. Phone ಮಾಡಿಯೋ ಬಂದು ಹೇಳಿಯೋ ಇವತ್ತು argument ಆಗೋದಿಲ್ಲ. You don't have the courtesy to come and tell a retired army person.
Sorry, my lord.
Yes, please argue.
Senior has to submit argument, my lord.
Cool. Madam, I am dismissing the appeal. Whenever you are ready, you please come and argue.
Please, my lord, kindly have it tomorrow, my lord.
Yes.
Kindly
Yes,
have
ma'am.
it tomorrow, my lord.
Huh?
Tomorrow, my lord.
Tomorrow at what time?
2:30, man.
Yes, 2:30 at the special agreement.
Please, ma'am.
If you don't come, madam, tomorrow it will be dismissed virtually. The Learned Counsel for the appellant submits that the arguing counsel is indisposed. It is seen that the respondent is a retired army person who has been waiting in the court from morning to evening. The counsel for the appellant has not even informed the respondent that the arguing counsel would be taken in an adjournment. That view of the matter is tomorrow at 2:30. It is made clear that it is made clear that the appeal shall be taken up for disposal based on the available documents.
Please, ma'am.
In this case, I appeal for the cross objector. He appeals.
Yes, where is Mr. Sabran?
I represent for the appellant, Your Honor.
You ready?
You are ready, Your Honor.
Really, sir.
They suit.
In this case, I represent for the appellant. Here only the item number 1 is alienated before in 1996 itself. Your Honor. Now this is not available for partition only. This is the
That
ground.
will say don't argue in the middle. First in the ಹೇಳ್ಬೇಕು ಕಥೆನ. Yes, please confirm.
In this case,
Yes, sir.
This is the defendant's suit, Your Honor. Defendant's appeal. First defendant has filed this appeal challenging the impugned judgment and decree passed by the lower courts. Your Honor. our only condition, if the defendants agree that, respondents agree that item number 1 of the social property
Sir,
is.
please don't, sir, you might know your case better than me, but your effort should be to convince me. So therefore, don't start from middle, start from the beginning.
I'm requesting if the respondent conceding for that, I will agree for only for item number 1 to be deleted from this case. That is the only point, Your Honor, from my side, Your Honor.
Whatever you want to appeal, you please appeal to the brother. If the brother accepts, then I don't have any issue.
Insofar as social item number 1, my lord, according to my contention of my learned friend, it is alienated. But the purchaser has not contested the suit all along. That my learned friend is alone contesting. It is the property which is acquired in the name of the appellant hearing in the connected matter. That's our case before the trial court. And the trial court has rejected, and the first appellate court has negated that contention. Against that, it is preferred now.
Yes, please argue.
As far as this, regarding this item number 1, the finding of the trial court before in the original suit, it has held that it is a self-acquired property of the defendant number 1 before the trial court, Your Honor. And in the appellate court, lower appellate court, it has been negated, saying.
Can we start from the beginning?
Yes.
Who are the plaintiffs and the defendants?
Plaintiff and defendants. Plaintiff is the sister of the defendants.
May
let him have the pleasure of arguing. Every day you appear.
Yeah, I am sorry.
In this case, at page number 57 of the ink page number, judgment of the trial court, Your Honor.
The plaintiff is a sister.
Yes, Your Honor. The plaintiff is that plaintiff and the defendants are joint family members. They are sons and daughter of the late B.S. Shivanna and Honna Gangamma. The Honna Gangamma has died in the year 1987 itself, and Shivanna died in the year 1981. Your Honor. The first defendant was the Karta of the family, social properties or ancestral properties, and acquired by B.S. Shivanna through ancestors. After the death of Shivanna, Honna Gangamma became the Karta of the family and looked after the same. Year. This is the case. There was no dispute. There was a dispute between the defendants about 5 years back. Hence, they were preparing separate food, but there is no division in the property of the family. The defendants are acting detrimental to the interest of the plaintiff. Item number 1 of the social property was acquired by the joint family funds. However, taking advantage of the Khata standing in the name of the first defendant is identified on 12/9/1996 in favor of the fourth defendant, which is not binding on the. Hence, the suit is filed. Your Honor, may kindly see regarding this, they have produced the stated purchase by me and also the alienation made by me, Your Honor. Regarding this, it has been finding has been given in page number 67 of the judgment, Your Honor. Now, may kindly see in page number 67. From the first line, it's basing on the stated exhibit P4. In this case, the documents clearly goes to show that the property is purchased in the name of first defendant. When the plaintiff dispute that it is the self-acquired property of the first defendant, duly cast upon him to establish the same. However, the materials available on record, it clearly established that it is a self-acquired property of the first defendant. Hence, the item number 1 cannot be considered as joint family property in relation to item number 23. That is survey number 17/3. Property is not in existence. Where it is the subfolded as 17/3A, 17/3B3C, Your Honor. In this case, Your Honor, kindly see the trial court has clearly held that there is no material to show that it is a joint family property earned in the name of the first defendant. Subsequently, in the 1996, has alienated the property. Hence, other properties we do not have a dispute regarding the partition or share allotted to each of the members.
No, but now, how does the first defendant establish that this is the self-acquisition?
The sale deed also stands in his name only. He has only paid the
The
consideration.
sale deed will obviously stand in his name, sir.
Yes, Your Lordship.
What is the? How did you generate money to purchase this property? How have you proved it?
we have given only oral evidence regarding the income that he was earning from his own pocket.
Gain income, how?
By doing business.
What business? What business?
I'll tell.
Business ಇಲ್ಲ copy of notice RTC ಮೂರ್ ಹಾಕಿದಿರ ಏನ್ business ಇದೆ ನಿಮ್ಗೆ?
I'll let you know in the deposition of the DW1.
ಆಯ್ತು ದೀರ್ಘವಾಗಿ ಓದಿ. Take your time.
Yes. And paragraph 5 of the deposition of the DW1, Your Honor. I swear that after the death of my father during the year 1981, mother was managing the affairs of the family during the 1985. All the members of the family started living separately, and at any point of time, myself was not managed the affairs of the joint family. During the year lifetime of BH1 of 4 defendants, marriage was performed. She is comfortably residing with his family at Iswanahalli. The plaintiff was also married during 1990, and she is comfortably living with her husband. That on 23/5/1974, I purchased the social property item number 1 out of my own earnings under the registered sale deed dated sale deed. There is no contribution from the joint family funds, and it is exclusively my own property. I swear that on 12/9/1996, same was alienated to one P. Nagaratna under the registered sale deed. The social property item number 1 was not inherited either by my father or to me. It is purely acquired property, and the plaintiff nor the defendants have no right, title, possession of the same to claim the partition. The plaintiff and other defendants are colluding and filed the above suit. The suit has been filed at the instance of second defendant, who is a teacher. And
where is your income? Where is the business? How did you generate? What is the total consideration?
Total consideration is not very much, a small amount of that is not a very.
Just a small amount.
I'll go through the series and tell you.
You don't even produce a sale deed copy.
Yep, it is marked here.
Huh? Who has marked it? Timber sale deed is produced, is it? Exhibit 24.
P24.
P24 is the one sided.
Right, is the list there.
1,000 rupees in 1974.
1,000 rupees in 1974 was a hell lot of money. Yes, 74 list.
And that too, Your Honor, kindly see, before this year is the daughter who has filed this suit. Before 1996 itself, it has been alienated, Your Honor. So this plaintiff who has filed this suit cannot claim the share in this property, Your Honor, because it has been already alienated.
When was it? When was it alienated?
1996, Your Honor.
Kumbar.
But in 1996, that it's a contention, my lord, it is all his contention, it is self-acquired property.
No, even if it is a joint family property,
my lord,
alienated in 1996, how are you entitled for a share?
But the contention, my lord, is that in 1974, but the property was acquired out of the joint family.
Let it be acquired of the joint family. If it is sold before 2005,
the purchaser, my lord, the purchaser has not contested the suit.
Correct. But how are you entitled for a share in the item number 1?
Property, my lord, now he has made out certain sites and other things, my lord, but he is contesting. So that is all his.
Fair enough.
Please.
No. If you yourself admit by producing exhibit P24,
yes,
suit item number 1 is sold in the year 1996-97.
Yes, sir.
And if you say that this is not the self-acquisition, but out of the joint family assets
Yes.
or nucleus, then you're not entitled for a share in this item number 1.
No, that is, it is our contention, my lord, is that of course that in 2005, my lord, that the alienations are saved, but insofar as the other things are concerned. But the contention, my lord, all along is that it is self-acquired property. So it is our contention, my lord, it is acquired out of the joint nucleus. When it is acquired out of the joint nucleus, my lord, but all the properties are available for partition, that is our contention. So that is accepted by the first appellate court. The trial court has rejected our contention because it is not the joint family property at all. So therefore, it is not available for partition. Based on that, the trial court has rejected our contention.
So we will take that this is a joint family property. We'll take it.
Please.
If it is sold before the 2005 Act, how can you claim as a co-parcel?
That co-parcel, but insofar as that proviso, it may affect my right. That I am not.
Therefore,
it is not affecting. But in
what are these 3 appeals? When the only cross objection,
cross objection that insofar as items 2, 6, 14, and 23. Otherly, that we have not produced any documents to show that the properties are not belonging to the family. That I have produced the additional documents along with this the cross objection, stating that the properties are acquired by my father through land grant, the land which is granted by the land tribunal. So that subsequently, you know that these 4 items of the properties are also the joint family properties, and therefore I am.
They're willing to give a partition.
Right. But now
they're willing to divide the properties excluding item number 1.
Yes, excluding item number 1 based on the sale made in the year 1996. It is not with regard to that. But
it will be easy. Hello, why don't you sit and at least sambandha uliyadi anta ashtene.
I do that we will sit across the table, then we will sort it out.
I can dictate a judgment and say that item number 1 is not available.
Yes, that
sambandha murdogutte anta ashtene.
I will look. I will advise my client also. Then we will see that.
ಯಾವಾಗ ಹೇಳ್ತೀರಾ? ಇನ್ನೂರು ದಿನ ಇದೆ.
After vacation ಹಾಕಿ ಯಾರು ನೋಡೋಣ. ಇನ್ನೇನಲ್ಲಿ ಆಗಲ್ಲ.
After vacation reach ಆಗಲ್ಲ ಸರ್. ಇವತ್ತಿನ ಫಾರ್ಚುನೇಟ್ಲಿ ರೀಚ್ ಆಗಿದೆ.
But day after tomorrow ಅಷ್ಟೊತ್ತಿಗೆ ನಾನು ಬೇಕಾದ್ರೆ tomorrow I will not be station. Otherwise I would have requested to last.
Day after tomorrow ಒಳಗೆ ಏನೋ ಮಾಡಿ ಒಂದು ಎಫರ್ಟ್ ಆಯ್ತು.
Note.
Except item number 1, you'll be entitled for a partition in respect of all the other suit items. Yes, Mr. Vishwanath.
Yes, we are considering for that now.
ಅವ್ರಿಗೆ ಹೇಳಿ ಕಾನೂನು ಪ್ರಕಾರ ಓದು ಸಿಗೋದಿಲ್ಲ.
Then I will advise to that.
Yes. Preferably if they amicably settle.
Yes.
ಏನೋ ಒಂದು ಸಂಬಂಧನ ಉಳ್ಕೊಳ್ಳುತ್ತೆ ಅಂತ ಅಷ್ಟೇ. Friday. Yes, Mr. Sidramaya. ಏನಕ್ಕೆ? ಹಳೆದು ತಂತ್ರ ಐತಲ್ಲ ಫೈಲ್ ಇಲ್ದಿದ್ರೆ. ಯಾವ್ದಿದು? ಸೀಲ್ ನಂಬರ್ 17 ಏನಾಯ್ತು? ಅವತ್ತೇನೋ FDP ಇದೆ ಅದು ಬರ್ಕೊಳ್ಳಿ ಆಯ್ತು. Counsel for the respondent seeks time. Counsel for the appellant seeks time. To pay process kattidire. Counsel for the appellant submits that the process and other requisites are deposited in the registry today to issue notice to the Yes, IA 1 to 3 to issue notice to the legal representatives of R1 of R2 in the notice author even. R1 to R4 you are appearing, Mr. So therefore you can appear for the children also. Full stop. At this stage, Sri B.B. Sidramaya, Learned Counsel, accepts notice for the legal representatives of R2. Full stop. There is no objection to allow the applications to bring the legal representatives of the deceased respondent number 2. In that way of the matter, IA 1 to 3 of 21 is allowed. Counsel for the appellant is directed to amend the cause statement. The Learned Counsel submits that file decree proceedings are already initiated and the commissioner is appointed for demarcation of the properties. Stop in that way of the matter, till the next date of hearing. All further proceedings in FTP number. In the next date of hearing, all further proceedings, the drawing up of file decree in FDP number. FDP number. Number code FDP number so and so on the file of the so and so is state. However, the final decree proceedings shall continue. Based on 30th May 2022. Yes, Mr. Pratap. You, why I insist is these are all small things. So therefore, I insist so that what happens is you tend to forget. We don't keep a diary. Counsel for the appellant submits that he has paid the cost. Office to check and verify. In the meanwhile, the counsel for the appellant is directed to comply the office objections within 4 weeks from today, failing which the appeal 5 weeks, 6 weeks from today, failing which the appeal shall stand dismissed for non-compliance of office objection without reference to bench. Counsel for the appellant has amended the office to check and verify.